I verified the records
Okay.
because
Item number?
47, Lordship. Respondent filed and obtained a stay order, Lordship,
It's okay.
in my maintenance case, Lordship.
But you can take it back. Alright. Learned Counsel Mr.
K. Majumdar, Lordship.
K. Muzumdar has
It may
responded.
come next week, 24th,
Earlier they didn't receive notice.
Lordship.
K. Learned Counsel Mr. K. Muzumdar has paid for adjournment, list the matter on 24/6.
Lordship, along with criminal revision petition number 158 of 25. And also, Lordship, the scan of the LCR, Lordship, office may issue reminder because that has not been received, Lordship. I verified the record.
Scan copies of the LCR as for is not received, issue reminder.
And in the meantime, I'll also file application for vacation of the red order, Lordship. Much obliged, Lordship.
Pleasure, Lordship. My lord, this is a criminal appeal. Accused is behind the bar more than 1 year and sentence is 5 years.
Court number 3. Court number 3.
Court number 3.
Yes, yes.
I have been told by that court that it should be mentioned here. Criminal.
You have to mention before court number 3.
May I please your lordship? I have to mention item number 35, madam. My lord, we have some difficulties today, madam. Can be on 25th, my lord. We are of the interim also, madam.
Learned Counsel Mr. D. Bora has prayed for adjournment, list the matter on. Interim order shall remain in.
Case has been received. No interim order, madam.
CD is here, madam.
So we have some difficulties today, madam. Can be on
CD is
25th,
received, CD to be retained till
25th, madam. Obvious, madam. Obvious. May I please your lordship? Also, I beg to mention item number 34, lordship.
yes, yes.
Lordship, we have certain difficulty, lordship, in this case. So we prefer 34. CD has been received, it may be retained, lordship.
Learned Counsel Mr. N. Alam,
NZS, SA Bhakhtiar for NZS.
S.A. Bhakhtiar for Learned Counsel Mr. N. J. Das has prayed for adjournment. CD is received. CD is received.
CD will be retained, lordship.
You have the CD.
Yes, lordship, CD has been received.
CD is received. List the matter on 24, 23rd. CD
Interim
to
is
be
there
retained
also.
till 23rd June. Day.
Madam, here also applicant CD was called for.
Yes, after the CD has fulfilled, it has been received.
After 15.
In 3. That this case is from which police station?
What else will you?
Udalguri. Little bit later on 27th.
After vacation.
Huh?
There is an interim,
You are on interim mail, no?
Yes.
And after vacation.
interim may be extended.
See,
We will turn that.
all these interim order, wherever we have interim order, we list it on vacation because this court is flooded with too many motion matters all these days. We won't be able to finish.
That's it.
Interim orders will remain in force till then. The vacation to DDR, ready to DDR. Then do. CD is not up to date. Send back the CD, call for the upload CD, is the matter on.
Interim may be extended also.
Of course, interim order shall remain in force till then.
20,000, interim may be extended also. Also.
My please, your lordship. My please, your lordship. Lordship, my prayer for listing a regular bail for motion, your lordship. May kindly on Monday, your lordship, 23rd.
It's more than 7 years old.
Lordship.
Offense more than
Let's
7
say
years
first.
old. Monday, no? Monday, Friday.
Lordship, I have another prayer, lordship. Daily list item number 13, your lordship. The PP name is not shown, your lordship, in the cause list, your lordship. But I have served the copy, your lordship. Hell, is
It's okay,
available or
it's
not?
okay. PP won't dispute with the copy.
May I please,
Please,
your lordship? Lordship, I beg to mention item number 25, lordship. Lordship, in this matter, lordship, the conducting council is out of station, lordship. Item number 25, lordship. Can it be on next week, lordship? Criminal revision petition.
Learned Counsel Mr.
D. Mary, lordship.
D. Mehdi has submitted that the engaged counsel is Mr.
Conducting council as Yasmin is out of station.
S. Yasmin is out of station. List the matter on after 3
Lordship,
weeks.
it is criminal revision petition, lordship. One truck is lying in the police station, lordship. Can it be on next week, lordship?
Not next.
No, no,
week.
after, madam.
Not next week.
Lordship, Lordship, I also beg to mention item number 30, Lordship. In this case, Lordship, case diary was called for, but case diary not available, Lordship.
Serious
30.
call for is not received, we should reminder list the matter on.
Can it be little bit shorter, Lordship?
Earlier, longer, shorter.
Shorter little bit. 26 June, of like.
May it please, my lord, I beg to mention item number 52.
Hmm.
With the consent of the other side, I'd like to pass over the case for today.
Item number?
Item 52.
Learned counsel Miss
A. Roy,
Aroy on behalf of
S.
S Sahu.
Yes, sir.
On behalf of learned counsel, Mr. S Sahu, with the consent of the other side, has paid for adjournment. List the matter under list the matter after vacation.
Much obliged.
May please, your Lordship. My lord, I beg to mention item number 45, my lord.
Hmm.
Excuse my lord, I am on interim, my lord. CD has been called for my lord. There is
Hey, Harrison, just a moment. I think I should change the counsel for respondent number 2. তেওঁ হেৰি নাই নহয়, এতিয়া চাকৰি পালেতো। Amicus Curie. She'll be joining as grade 1 officer, no?
She was selected, but
She's selected, then can she continue to work now? She cannot, I think, and she should not. Otherwise, if I won't change now, then it will take some more time. Yes, she's working. Okay.
my lord, item 45, my lord. CD, my lord, has not received, my lord. I am on interim, my lord. Maybe, my lord.
CD item 45.
45.
Yes,
45, somebody, I think, somebody has just,
CD has been called for, my lord.
now you have
The-
CD to लिखा नहीं ना? Issue reminder to forward the CD.
Item
Date
45.
yes, yes.
Huh?
45 को मैं 25 को
My lord, interim order passed earlier on account.
फिर लिखा असल की interim order shall remain in force till then.
Interim may be continued.
CD not here.
May it please your lordship. So I am praying for listing of an anticipatory bail application for bail hearing on Monday, lordships. It was last listed on the 2nd of June, but it was, it did not reach and left out, lordship.
Period of imprisonment,
Lordship, it is
more than
not,
7 years.
it is to be listed before lordship because lordship has earlier
rejected it.
earlier decided the bail application of co-accused person, lordship. That is well, lordship. On Monday, lordship, obliged.
Thank you.
May I please, your lordship? Item 33 to be taken up at 2 p.m. You know, wrong file has come, my lord, here. And my
Okay.
lord will send again.
Okay, at 2 p.m. Okay.
33 at 2
Here
p.m.
in the cause list, my lord, PP not shown, my lord. That's a part.
Cause list, what is?
33.
Yes, what
33.
about cause list?
My lord, in the cause list, PP name not shown, my lord.
At 2 p.m. be a hearing. Yes, but
1906/2025.
but the office of the PP may not wrongly written the case number in another petition.
At 2, okay?
At 2
We'll
p.m.
sort it out at 2. Yes.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 38, lordship.
Hmm.
We are on interim, lordship. The updated case diary is required, lordship.
Council Mr. V.H. Chaudhary. You have the CD?
My lord, CD but not up to date, my lord. Statement is not here, my lord.
Is present for the petitioner. Learned additional PP Mr. B. Somai submitted that CD is not up to date. Send like the CD, call for the up to date CD, list the matter on. Interim order shall remain in force till then.
The interim may kindly be
Yes, it's.
deeply obliged.
May I please, your lordship? I beg to mention 2 norms of bail application, lordship, for withdrawal for tomorrow, lordship.
Bail application.
Withdrawal. lordship. Deeply obliged.
May please, lordship. Item number 40 may can be adjourned for the day only. May can be fixed in the next week, any day.
CD is available, my lord.
Learned Council Mr. M. Rahman
Number of.
has prayed for adjournment. CD is received. List the matter on. CD to be retained till then.
My
May it please your lordship. I beg to mention item number 18, lordship. Learned Counsel G. Bordolo is out of station. Matter may be adjourned and fixed next week, lordship.
What is your name?
NJ Daimari, lordship.
Learned
18.
Counsel Mr. L.J. Doimari.
Yes.
Has
Lordship, kindly-
committed that Learned Counsel Mr. G. Bodley is out of station. list the matter on after vacation.
Lordship, it would be much better if next week, Lordship. Which, because trial is
No.
not possible.
Admission matter cannot be fixed next week after vacation. We'll
Obliged,
fix a date, date is a detail.
obliged.
Notification has been circulated, so no matter, only motion matters will be taken up. Number one.
May I please, Lordship, an application under section 483 BNSS. Lordship, the accused is behind the bars since 23/05/2025. Today is, Lordship, 28 days. Lordship, the allegation is under section 61 plus 2, 318 plus 4. 360.
Abatement, cheating and misappropriation,
Yes, and forgery, Lordship.
forgery.
Lordship, at this stage, CD may be called for
Call for the CD, list the matter on.
26 or 27, Lordship, before vacation.
This is from Guwahati.
Lordship, this will be yes.
This problem.
Deep levels.
Lordship, this is a 483 bail application, Your Lordship.
Mala charge-sheeted case, my Lordship, may call for scan remand.
Under sections 482.
457, 376 and 506 of the IPC.
Okay, let us call for the scan.
Your Lordship,
Call for
may
the
give a
scan.
start date.
Okay, from which place?
Place, Your Lordship.
Charge-sheeted case, ma'am.
Gosaigaon. Police
Gosaigaon.
Station.
Okay, call for the scan copies of the trial court record along with the consolidated CD. This is the matter of 25th June.
Before charge-sheeted case. Charge-sheeted case.
No, Lordship, before vacation.
I can see.
Next is the Lordship.
Same matter.
Yes, Lordship.
Same matter.
Same.
No, my lord, here is the allegation is against the Pulwama, my lord, incident, my lord, Pulwama incident, my lord. Yes, even some, my lord. That's me call for CD here, my lord, from Vishwanath, my lord.
The same case. All
No,
those
Lordship.
cases, that same case.
No, my lord, earlier here, my lord, that's me kindly use the, my lord, page 17, my lord. Page 17, my lord, rejection order put below, my lord. 16, my lord, perusal of the record and case diary, it is found that there is incriminating material against the accused as the informant Kiran Pego of Orago Swenso. FIR stating that accused Onil Punya made public statement in social media which are seditious, misleading and potentially detrimental to the unity and integrity of India. A video circulated accusing the central government of India and orchestrating the Pulwama and Pahalgam terrorist attack which were perpetrated by Pakistan-sponsored terrorists which result in death of 26 innocent individuals. The statement made by the accused intended to
Okay, let's
incite
call for
public.
the, CD then.
City miles.
Call for the CD, list the matter on.
Yeah, please, Your Lordship. My lord, this is a regular bail application, my lord. I am behind the bar for 72 days, my lord. Investigation is already over, my lord. Police has submitted charge sheet, my lord, and trial has already, my lord, started, my lord. So at this stage, my lord, my detention may not be required, my lord. I am only 19 years old, my lord. So I am local person, my lord. So with any stringent condition, my lord.
Let's say me call for scan copy, my lord, charge sheet after investigation, my lord. Getting materials, my lord. I will submit charge sheet, my lord. Let's say me call for trial.
Kindly
court
see, my
record,
lord, FIR, my lord, at page 16. No whisper about my any kidnapping, my lord. Kindly see.
Call for the scan copies of the trial court record, kidnapping.
Kidnapping.
List the matter,
Well,
call
short.
for the scan copies of the trial court record along with the scan copies of the CD, list the matter on 27 June.
June. Oh, bless.
You want it on July?
It will be
then I can-
difficult, my lord. Around 7 most of the matters will come, my lord, in the next week, my
My
lord.
lord, he's 72 days, my lord.
Only 72 days, my lord. Here is the charge sheet also submitted, my lord.
Lord, I already approached the trial court, but trial court rejected my plan.
You won't complete.
It
the-
will be harsh for us
It will
also,
be-
my lord, in the next week, my lord.
If you won't be able to read the scan copies, if you won't be able to complete, it will be remain a chapters left to go.
Okay. That humanly.
Humanly, only if it is humanly possible, you can complete reading those scan copies, voluminous scan
It will be
copies.
difficult for us also.
I understand.
Next week, my.
Yes,
26, 27.
it will be left over. They are asking, I am giving them the date.
May I please, sir?
Item?
Lordship, my finish let's now, matter may be taken up as some.
After some time.
Item 6.
69.
May I please, it is a charge sheeted case file or the scan copy of the records may be called for
All for the
after,
scan copies of the child court record along with the scan copies of the.
but it is after vacation, my lord.
Okay. Vacation officer. 15 July, thank you.
Obliged.
Thank you for understanding our problem.
Obliged.
May I please, your lordship. With regular bail application, my lord, FIR has page number 10, my lord. Very good. In reference to the subject cited above, it is to inform you that on 7/2/2021, when I came to my residence as Kukarpar of Borbeta at 9:30 AM from Guwahati, and I found that though the front gate of my residence is locked, but the inside door is broken, and found that at amount rupees 2 crore, which was kept at Almira for purchasing land for setting up a clinic, are stolen along with golden ornaments. Moreover, my residence, a CCTV connection along with GeoFiber was installed for security purpose, where the hard disk along with DVR has also been stolen with an intention to erase the evidence, and the GeoFiber number and so and so is also found stolen, my lord. This is the case, my lord. During investigation, I have been arrested, my lord. Kindly see the forwarding reported page number 11, my lord. Three persons were arrested, my lord. I am number 3. I am number 3, Rahman Mullik. And my ground of arrest below, my lord. Number 2. That the accused Jahangir Ali has given his father, namely Ansar Ali, rupees 20 lakh for purchasing land. The accused Ansar Ali has purchased a plot of land measuring 1 biga 90 lesa from Khalil Ali of so at rupees 19,95,000, and the accused Ansar Ali has already paid
For city, my lord, views.
with the Khalil
19
2
lakhs,
rupees so.
19 lakhs 50,000 only recovered.
Behind bars.
My lord, I am 25 days, my lord. Next, one number 3, kindly see the number 3 ground of arrest. During investigation, it is revealed that the accused person was apprehended at so and so, and on questioning, they confessed that Jahangir Ali purchased a Alto K10 car bearing registration number so and so, and Magic Mantra bearing registration number so and so. I am a driver, my lord. I have been taken death Magic Mantra from Jahangir Ali on contract, my lord. Therefore, that Magic Mantra has been recovered from my possession, my lord. Therefore, I have been arrested. I am no way connected with this case. Can you see the, my lord,
We'll
page
need the
30?
CD.
My lord, city, my lord,
Believe
sir.
you will, but we'll need the CD.
My lord.
Call for the CD, list the matter on. It is from
Sorted,
which
my lord,
place?
before vacation if possible.
Which place?
From Borpeta.
It won't come.
Right.
14 July.
Today 25 days already.
It won't come, I think, before, from Borpeta, 14 July.
Please, your lordship. Lordship, regular bail application, 65 days behind the bar, 90 days offense. It may be call after vacation, lordship.
CD?
CD.
Call for the CD, list the matter on.
8, no? I think.
Lordship, on 15, it will be 90 days. On 14, maybe call. Obliged.
I'm for the petitioner.
Hmm.
I filed bail application against Boko PS case number 152, 2025. And that's on 329, 474, 76, 64, 162 BNF
এটা
Miller.
বন্ধ করে দিন।
As per Izahar Miller.
Lordship, regular bail application, call for city lord.
Call for the city, list the matter on after vacation.
Lordship, before vacation, lordship.
Before vacation, final decision. From which police station?
Bokhista lordship.
Huh?
Bokhista lord.
Oh, detail.
27 June.
Item 9.
May I please, the Lordship? Lordship, this is a charge sheeted case and the related matter with regard to causing of the matter is at item number 46, which is listed today, Lordship. The record has been called for on the last occasion. Your Lordship, kindly see that matter also item number 46. Now, what has happened, Lordship, initially the case was registered under section 341, 325 and 34 IPC. These are all bailable sections. But subsequently to put undue pressure upon the petitioner's Lordship, the section 307 has been added. Although there is no material on record which shows the ingredient of section 307. Even the learned trial court at the time of adding that particular section made a mention with regard to the fact that there is no allegation as such with regard to this attempt to
Where is the FIR?
FIR, Lordship, is at page number.
Charge has been submitted.
Yes, Lordship, charge sheet has been submitted under section 307. The FIR, Lordship, is at page number 13. Basically, it's a landlord tenant matter, Lordship. The informant, they are the tenant in the suit premises, Lordship. And to put undue pressure upon the petitioners or the landlord, Lordship, this FIR has been lost. I'm just reading that particular FIR, Lordship, is at page number 13. I have the honor to state that the accused persons are tenants at the above address. They have admitted that thing, Lordship. And my brother-in-law, Nikhil Roy, and my another brother-in-law, husband's younger brother, Nilu Roy, reside as tenants at END Colony, Tarapur. After my son, Kumar Roy, had stayed for some days in the rented house of my brother-in-law for the month of January 2018, around 4 p.m. on 2/3/2018, when Sanjeev Roy and Taposh Roy, sons of elder brother of husband, and Nilu Roy, the younger brother of my husband, went to the house of Srimati Shoma Roy, a tenant in the house of the accused persons, taking along my son to attend an invitation. The accused persons detained my son and assaulted him on his head and various parts of his body by means of sharp weapon and rod, and thus caused severe injury to him without any recent reason. My son became unconscious and the elder brother of my husband and others took him to SMCH and provided treatment to him. Having learnt about the incident, I went to see my son as his condition was not well. I again took him to SMCH, whereupon doctor referred him to Negrim Hospital. And accordingly, I immediately took him to that hospital and provided treatment to him. The lodging of the Ejahat, there is a delay of 1 month, Lordship, and the explanation, Lordship, kindly see. The lodging of the Ejahat got delayed as I was busy with the treatment of my son and as the accused persons assured for an amicable settlement of the matter. So this is the basic reason, Lordship, for which there is a substantial delay of 1 month in lodging the FIR, Lordship. Now, at the initial stage, at the time of registration of the FIR, Lordship, the next page, section 341, 325, and 34 was added, Lordship.
Yes.
I am just praying for interim protection, Lordship, with regard to section 307.
My lord, here, in this case, my lord, charge sheet submitted, my lord. Charge sheet submitted, Lordship may call for. কোনটি কেসে রাইছেন 46
46 তো আমি চার্জ শিটে চ্যালেঞ্জ করছি না এন্ড এটা আইটেম নাম্বার 9
If I grant interim protection.
My lord, here, Lordship, I will, Lordship, here is a charge sheet case, my lord, Lordship may call for scan copy also here, my lord, trial court record, my lord. This is the, my lord, consent. After perusing by that charge sheet and other methods, my lord, Lordship may consider the prayer, my lord. At this stage, Lordship may call for scan copy.
Let us call for a scan.
Lordship, I am praying for protection, Lordship, for section 307 because the learned trial court at the time of adding that particular section even made a mention. I'm just referring to page number 20, Lordship.
We'll have to.
Lordship, kindly see that
Page
particular paragraph, page number 20. The statement under section 161 also referred to there, Lordship. The second paragraph. Hard peruse the case record. Lordship, kindly see page number 20. Hard peruse the case record, case diary and medical report. On perusal of the case diary reveals that the statement of the witnesses recorded under section 161 CRPC, that though none of them in their statements have explicitly stated that the accused had assaulted with intention to kill. So this
It is in the FIR.
Lordship.
Hitting him with a hard object on the head. What does that mean?
Lordship, this section 325 is
It
there,
is in
Lordship.
the FIR.
Section 325 is there, Lordship, and there is a delay of 1 month in lodging that FIR, Lordship. And the medical records which are attached with this charge sheet also lordship is no way resembles with the allegation of
You see, this is a
637.
Signal case, we'll have
My
to call for the scan copy.
Also, some interim protection may be given lordship.
We'll call for
because-
the scan.
File a
copies
scan
of the
copy.
trial court records.
Short date may be given lordship.
Yes, can be, and that 43 also.
Lordship. 46 also lordship. In the last occasion, scan copy was called for.
The scan copies of the trial court records, list the matter on.
June. Always. Always lordship. Lordship kindly make a mention lordship with regard to the interim will be taken into account lordship on that particular thing.
The petitioner's prayer for interim protection may be considered on receipt of scan copies of the
Yes,
trial court records.
Always lordship.
Read and take it.
Well, annexer 1 minute Azhar, page minute 8. And 11% minute, that is minute page 10.
AB or PA?
Minute
AB maybe.
8, every minute. In the fact is this minute, there is a some police personnel, they were doing their patrolling duty minute night. And some persons are found that they were loitering near the ATM machine of some bank minute. And all of them were arrested and they found some instruments, etc., gas cutter, etc. But my name, one of the accused name mentioned my name. There is a the case, English mill.
Lordship may call for CD, my lord.
Let us call for the CD.
My lord.
Call for the CD, list the matter on 15 July.
May I please, Your Lordship? Here, my lord, the father of the present petitioner was, my lord, murdered, my lord. And all the sons and relatives, even the mother also implicated in the case by brother of the deceased.
We'll have to call for a
My
CD.
No, because, my lord,
Call for a CD,
My
list
my
the.
lord, some of, no, my lord, the mother was, police did not arrest the mother, my lord, Fatima. And other brothers have been released by the session judge, my lord. Now, these two petitioners are, my lord, staying at Chennai. Your lordship, can you look into the,
No, murder case.
16-7.
Murder case. I'll directly look into the CD. Murder case.
no, other brothers have been released, my lord, who are present here, who has been arrested, they have been released. I have also annexed the order also, my
We
lord.
need the CD.
My
May I please, Lordship? In this case, my lord, the allegation is, my lord, by promising to marry Lordship, established relationship, my lord, and 2 rupees, my lord, 3 lakhs, my lord.
It is there.
No.
How it is
Maybe the CD is in the.
my lord in which court?
CD in High Court, you'll see in connection case CD was received. Yes.
No.
These people will go mad
My lord.
in the office.
On Tuesday,
Track
your
the
lordship,
CD.
may kindly on 24, your lordship,
How will they take the CD within these 4 hours?
24, your lordship.
Call for the CD, list them at 24 fine. This you go. Belageta did? 23rd,
24, your lordship.
23rd on 23rd.
Yes. Oblige, your lordship.
May I please, your lordship? My lord, it's very unfortunate, my lord, the informant's husband, my lord, accident, my lord, during while he was crossing the road, my lord. And the petitioner before your lordship, my lord, he is driving the motorcycle, my lord. May I kindly see the FIR, my lord, vernacular page 13, my lord. May I read, my lord? Page 13, my lord, vernacular.
Please read.
Yes, my lord. সম্মানপূর্বক তথাবিহিত এজাহারকারী বিনীত নিবেদন এই যে এজাহারকারিণী মন্টুরাম মণ্ডল পিতা মৃত খুশি মোহন মণ্ডলৰ বিবাহিত স্ত্ৰী হয়। এজাহাৰকাৰী স্বামী মন্টুৰাম মণ্ডল যোৱা এত তাৰিখে সন্ধিয়া অনুমানিক 7:30 মান বজাত ঘৰৰ সমীপতে থকা তুফান বজাৰৰ ওচৰত গোলাম মুস্তাফা নামৰ গেলামালৰ দোকানী এজনৰ দোকানৰ পৰা ঘৰুৱা সামগ্ৰী কিনি লৈ ঘৰমুৱা হৈ থাকোতে দোকানৰ সন্মুখৰ কীৰ্তনপাৰা চয়ঞ্চৰ আছে বজাৰৰ পৰা বৰচোলা অভিমুখে গৈ থকা এখন অতি দ্ৰুতবেগী মটৰ চাইকেলৰ চালকে তেওঁৰ মটৰ চাইকেল পঞ্জীয়ন নম্বৰ 54খন চলাই আহি এজাহাৰকাৰিনীৰ স্বামীয়ে ৰাস্তাৰ বাওঁফালেদি খোজকাঢ়ি গৈ থকা মুখামুখিভাৱে প্ৰচণ্ড জোৰে খুন্দিয়াই দি তেওঁক পকী ৰাস্তাত পেলাই দি পলাই যায়। এই দুৰ্ঘটনাৰ ফলত এজাহাৰকাৰিনীৰ স্বামীয়ে তেওঁৰ শৰীৰৰ বিভিন্ন ঠাইত গুৰুতৰ জখমপ্ৰাপ্ত হৈ সংজ্ঞাহীন হৈ পৰে। লগে লগে ওচৰৰ মানুহে এজাহাৰকাৰিনীৰ স্বামীক অচেতন অৱস্থাত তুলি লৈ গৈ 108 গাড়ীৰে বঙাইগাঁও চিভিল হস্পিটেলত পৰিয়ালৰ লোকৰ দ্বাৰা চিকিৎসাৰ বাবে প্ৰেৰণ কৰে। কিন্তু হস্পিটেলত গৈ যোৱাৰ লগে লগে ডক্টৰে পৰীক্ষা
So
নিৰীক্ষা
we
কৰি
need the CD.
My lord, kindly see, my lord. My lord, I have annexed my driving license also, my lord. It's an accident case, my lord. Rush and.
Accident nowadays.
My lord, kindly see the
You
section.
cannot say.
My lord,
we
kindly
are
see the
saying
section
Bengal
charge
is
here,
an
my lord.
accident
My
case
lord,
that
kindly
you
for
are-
a moment, my lord. Kindly for a moment, my lord.
Accident case with causing death is now imprisonment. is
Kindly see the section.
What is the period of imprisonment? 2 years.
My lord, which, my lord, section, my lord, here 281 and 105, my lord. 281 is bailable, my lord. 105, my lord. There must be some intention or knowledge, my lord, to cause death, my lord. It's accident, my lord, in the road, my lord, while he crossing, my lord. There is some, my lord, accident, my lord. The petitioner before your lordship, my lord, he also, my lord, sustained some injury, my lord. That's why, my lord, he could not take him to the hospital, my lord. The nearby people came, my lord. He took the, my lord, the victim to the hospital, my lord. He was also sustained injury, my lord, in his leg, my lord, the petitioner before your lordship, my lord. I have annexed the driving license also, my lord. It is my brother's vehicle, my lord, motorcycle, my lord. Well, I am not saying anything, my lord. My intention was not there, my lord. It was accident, my lord. It happened, my lord, sometimes, my lord. It's very unfortunate, my lord. But, my lord, his intention, my lord, to kill him, my lord, that is not there, my
It
lord.
was booked under this
My lord, that-
negligence.
10
105 is not negligence.
No, my lord. 281 is negligent, my lord, rash driving, my lord. But 105 is, my lord, punishment for culpable homicide, not amount to murder, my lord. That is, my lord, 5 to 10 years.
That is
But
accident.
knowledge must be there, my lord, and
Causing
intention must be there, my lord. That is not there, my lord. In the road, my lord, kindly see the address of the petitioner and the victim, my lord. They are from some different
I'm
person.
not saying I'm rejecting the bail.
My
I'm
lord.
saying that I'll call for the CD.
Yeah, but till then, my lord, interim, my lord, because anticipatory bail, my lord. My lord, kindly see, my lord, no knowledge and intention, my lord. It was accident, my lord, in the,
I'll call for the CD and
Yes.
then we will grant it.
it is in the highway, my lord. Kindly, my lord,
Yes,
that
sir.
matter, kindly be looked into, my lord.
Definitely. I'll call for the CD. Call for the CD, list them.
Then prior to, my lord, vacation, my lord.
Now the code has been changed.
Obliged, my lord. 15 July, দিলেন না?
Back to your lordship. Kindly attend the timing for lordship.
Time being. Okay.
Privilege. Yes, sir. May I please, lordship? Lordship, in this case, lordship, the allegation was made against the petitioner was that the petitioner has made some comment against India during India-Pakistan war of Operation
Yeah,
Sindoor.
we call for the CD.
So, senior report, lordship.
Call for the CD, list the matter on.
Can it be on 17 July?
17 July.
17 July. In the interim, lordship, some protection may be given.
No.
No, courtship action may be
No, no.
taken.
Why?
May I please, your lordship, anticipatory bail, your lordship. FIR, lordship, Varnacular has paid 16, your lordship. Allegation is abatement of suicide.
We'll call for the CD.
Lordship, kindly see the FIR.
You are
And
the
the-
husband?
I am not the husband, lordship. I am not the husband. I am not the relative. Actually, the petitioner and the petitioner number 1 and petitioner number 2 are mother and son, your lordship. And the victim, there was a relation, love affairs between the lordship petitioner number 1. And against that love affair, the family members of the deceased were not agreed due to financial low income on the reason that the petitioner number 1 earned low income. And for that reason, they doubt, they have suspicion that the informant sister committed suicide, your lordship.
Please read the FIR.
Lordship, kindly, page 16. বিনীত সন্মানপূৰ্বক নিবেদন এই যে আজি আনুমানিক প্ৰায় 1.5 বছৰ মানৰ আগৰ পৰা তিনচুকীয়া টাউন পাঞ্জাবী গলি শ্ৰীপুৰীয়াৰ নিবাসী মৃত চৰণ সিং আৰু মৃত পৰমজিৎ কৌৰৰ পুত্ৰ শ্ৰী ওংকাৰ সিং লৰ্ডশ্বিপ পিটিশ্যন নম্বৰ 1 মোৰ প্ৰায় 26 বছৰীয়া ভণ্টি শ্ৰীমতী মনপ্ৰীত কৌৰৰ বিভিন্ন ধৰণৰ প্ৰলোভন দেখুৱাই ভাল পাই আছিল। এইখিনি কথা আমি অনেক দিনৰ পিছতে জানিবলৈ পাইছিলোঁ। তেতিয়ালৈকে উক্ত ভালপোৱা ভণ্টি আৰু শ্ৰী ওংকাৰ সিঙৰ বহুত আগবাঢ়ি গৈছিল। আমি আমাৰ উক্ত ভণ্টিক সদায় আৰু প্ৰায় ঘণ্টা ধৰি মোবাইলত ফোনত কথা পতা প্ৰত্যক্ষ কৰি আছিলোঁ।
মই আৰু আমাৰ মা শ্ৰীমতী চৰণজিৎ কৌৰে কেইবাবাৰ বাধা প্ৰদান কৰে, কিন্তু শ্ৰীমতী পৰমজিৎ কৌৰে মোৰ ভণ্টিক বেছিকৈ উচ্চতাই দিয়া। পৰমজিৎ কৌৰ ইজ পিটিশনাৰ নাম্বাৰ 2, মাদাৰ অফ পিটিশনাৰ নাম্বাৰ 1 বুলি আমি এক বিশেষ সূত্ৰে জানিবলৈ পাইছিলোঁ। হঠাৎ আজি প্ৰায় এসপ্তাহ মানৰ পৰা আমাৰ ভণ্টিৰ স্বভাৱবোৰ আগৰ দৰে নাছিল। প্ৰায় অকলশৰীয়াকৈ থাকিবলৈ ভাল পোৱা, কথাই প্ৰতি তৰ্ক কৰা ইত্যাদি। যোৱা ইংৰাজী 22/5/2025 তাৰিখে পুৱা 7:30 মান বজাত মই আৰু আমাৰ দেউতা শ্ৰীযুত মহেন্দ্ৰ পাল সিং উক্ত ঘৰত নথকা অৱস্থাত আমাৰ ভণ্টি মনপ্ৰীত কৌৰ নিজ উৰণি দুপট্টাৰে ডিঙিত লগাই চিলিং ফেনত ওলমি আত্মহত্যা কৰে। এই সন্দৰ্ভত আমাৰ উচ্চ পৰিয়াল শ্ৰীমতী পৰমজিৎ কৌৰ আৰু পুতেক শ্ৰী অংকাৰ সিঙৰ ওপৰত সন্দেহ হৈছে, your lordship. সন্দেহ। CD may be
Call for the CD and
CD
if
madam.
you won't get anything, we'll grant
Madam.
bail. I
Lordship,
have granted bail in.
Lordship,
suicide.
mother is the petitioner number 2 is old widow, your lordship. Old widow, your lordship. And lordship,
Number 2.
and your lordship, from the material, from the
Okay,
ingredient,
only petitioner number 2, grant interim bail. Petitioner
Lord,
number 2.
lordship, kindly see the ingredient of
No, my lord, it is not.
ingredient. There
Without
is
CD,
no,
my lord, it is not.
Petitioner number 2, I am granting interim
Madam.
bail.
that is lordship, in respect of, I would like to, in respect of petitioner number 1, lordship, I would like to submit a judgment, your lordship,
No, no,
of
no.
this honorable court.
After getting the CD, I will go to the.
Lordship.
Our learned counsel, Mr. A.R. So,
Yes, Lord.
for the petitioners at Duzon Deliver, we have filed this application under section 482 of the BNWS 2023 with prayer for prayers bill as they are apprehending arrest in connection with so and so PS case after so and so seconds. Heard Mr. B. Sharma, learned edition PP Assam. The allegation against the petitioners is that the petitioner number 1 had a love relationship with the victim who has committed suicide. Further alleged that the petitioner number 2 had incited and induced the victim the informant suspects that the petitioner number 2 is also involved in abatement of suicide. Full stop. The abatement of ABET. It is further submitted that the petitioner number 2 is an elderly lady, aged 45 years old. Full stop. The rule attributed to the petitioner number 2 does not make out an offense of abatement to commit suicide. I have considered the submissions at the bar with circumspection. I have considered the age of the petitioner number 2. It appears that interim bail may be granted to the petitioner number 2. Call for the CD, list the matter on 17 July. In the interim and in the event of arrest, the petitioner number 2, Poromjit shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner number 2 shall appear before IO within 1 week and cooperate with the investigation. The prayer for prayers bail of petitioner number 1 will be considered after receipt of CD. Call for the CD, list the matter on.
Oblige, your lordship. Maybe lordship, this matter maybe adjust the timing. My senior will appear in this case. Keep your words. Item number 90 for every subject.
Hey, revision, washing.
May I please, Your Lordship? My lord, I am before your lordship for quashing the criminal proceeding. Here, my lord, husband and wife. The husband filed the
FIR and charge sheet both are given. Submitted. FIR is in page 25.
We have the LCR, no? LCR, sir?
LCR is coming. And 164 statement may be not with the LCR. Whether it is come or not, my lord.
I think it is there, my lord.
Is it settlement, settled issue or
No, no,
tested issue?
it will, crossing.
Oh, good. Yes.
But in the FIR, my lord, initially it was registered under section, my lord, 498A, 325, 307, 506, 294. But later on, my lord, when the investigation is complete, charge sheet is given on, my lord, only 498A section. The allegation is basically, my lord, kindly come to the page 25, that is stated copy of FIR.
Yes, page 25 years.
May I read?
Yes.
It is respectfully beg to state that I, Sri Nibiri.
Dima, we have called for a report. You have the report,
My lord, that report I have received.
not required for further investigation.
Then last line they have.
Okay, then this is at the stage of investigation.
No, my lord, charge sheet
Charge sheet
submitted, my lord. Here also.
It's updated.
Charge sheet also submitted, my lord.
Then whom should we direct to? We'll set aside the other order, no?
My lord.
That earlier order.
My lord, earlier rejection, my lord.
That is at page number 35, my lord.
So now whom should we direct? The OC?
OC.
Lying in the Thana?
OC, my lord.
Thana?
Thana.
Which?
That is
Gosaigaon.
Gosaigaon, yes, my
Gosaigaon.
lord.
After proper verification of the, my lord, documents regarding the owners.
Please help me. I'll dictate now.
Mine.
You help me with the dictation. Otherwise, I'll keep forgetting one point after the other. Our learner counsel, Mr. S. Anand, no?
And
N. Anand. N. Anand, from our learner counsel for the petitioner, Joy Bhagwan, who has filed his application under section
And owner.
528 of the BNWS 2023 with prayer for Zimma of the vehicle bearing registration number HR 46F hyphen 4203 within bracket goods carrier hyphen HGV bracket close seized in connection with Gosaigaon PS case number 127 of 2024 under section 20 within bracket C bracket close stroke 2529 of the NDPS Act 1985.
Ariana.
The petitioner's prayer for Zima was rejected by the order dated. Which one?
order dated, page number, my lord. 30, order dated is 29/8/2024.
It is not required to be set aside, I think.
No.
Now charge sheet has been submitted.
Charge sheet submitted, my lord.
Set aside by the order dated 29.
8,
Which page?
page number 35.
Page number, okay.
Oh, no.
Not page number 35, no?
No, no, no. Oh,
This is for report.
my lord.
You have not annexed the order. I'm sure you have not annexed the order.
Yes, my lord. That is mistake.
So is this petition maintainable according to the rules? You have not annexed the order which has to be set aside.
I'm not here praying for the setting aside, my lord,
Hmm.
because this is not a revision petition.
Okay,
I may be direction.
okay then, we'll continue. We'll dispose it of what is the point. Set aside order dated nalage, the petitioners, the petition, it is submitted that the petitioner, that charge sheet has been laid against the, he is the accused.
He is the petitioner, my lord, not accused.
No, he is not accused.
No,
It is submitted that the petitioner is not the accused in connection with the aforementioned
yes.
case. Heard Mr. B. Sharma, learned additional PP Assam. Who has submitted that a report has been forwarded by the IO. Who stopped seen the report of the IO. That charge sheet has been submitted against the accused persons. Sulendra Kumar, Bante Kumar, and Durbin Singh, by CS number 142/2024 dated 31/10/2024. And the vehicle seized in connection with this case being Gusaigaon PS case number 127/2024 is no more required by the IO for further investigation. Full stop. I have considered the submissions. It is submitted that the vehicle may be handed over to the registered owner.
Is that not the registered owner, my lord?
That is the page number 12, my lord. Page number 12 is
It's not the
the,
registered owner.
he is the power of
It is last sentence to Katija.
At page number 12, my lord.
It is submitted that the petitioner is the power of attorney.
My lord.
Page number 12.
My lord.
Power of attorney holder
My lord.
of the vehicle. It is a company.
It's a company, my lord. Bhavi Logistics.
Okay.
At Haryana, Rohtak. It's a transport company, my lord.
As a vehicle is not required for further investigation, Kumar, the OC of which police station?
Gosaigaon, my lord.
Gusaigaon Police Station may hand over the vehicle to the petition in.
Registered owner, my lord. After
To the registered
verification,
owner.
registered owner, my lord. After
My lord, no
proper
problem.
verification.
Mono
To
Kumar, that
the registered owner after proper verification of the documents and after ascertaining the ownership of the vehicle, subject to the condition that that an undertaking is executed by the registered owner or by the petitioner?
Registered owner, my lord.
By the registered owner to produce the vehicle as and when required by the court for an amount of rupees, how much?
50,000.
It's a
Because
tanker.
It is
I-
truck, my lord. It
it's
is
a
a truck, my lord.
Truck, what is the value of a truck?
My lord.
on that.
10 lakhs.
Huh?
10 lakhs.
10 lakh.
Basically, more than 10 lakhs.
Yeah, it would be more than,
More than 10 lakhs.
Then you are a company,
my lord.
10 lakh. Mazot and the
And they
the
sell-
vehicle is in the premises of the Heri Thana will liquid. Which Thana?
Gosaigaon.
They cannot sell, my lord, sell the vehicle
No,
also.
with the undertaking to produce the vehicle
As and when required.
and not to alienate the vehicle
My lord. As and when required. my lord.
required. Or should I include this also? Not
lord.
to sell the vehicle
My lord, they cannot.
and not to alienate the vehicle, will you liquid? The report of the OC will form a part of this. report.
Well-
In terms of the above observation, this frequency that is posted.
My lord, this also originates from this FIR only. Here, my lord, some consignment was sent by this truck, my lord, of item number 21. And those consignments, as per the report of session judge, reject order, my lord, at page number 31, those consignments were not seized, but still it's loaded on the truck. This truck that my lord has released.
Consignment?
That is some scrap material of plastic bottles, valuing to something around 2,85,088,000, my lord.
A report was called.
My
for-
lord, here we have received only that search sheet submitted, my lord. That report is here. but that regarding that not received any.
Kindly produce that page number.
That consignment.
It's not seized. As per the report, my lord,
We
reject
have
or
seen and
My
then there is a judgment of the DB, no? If that's articles are not seen, there's a judgment of this division bench.
it's not
During
seized.
investigation.
Still there in the truck, my lord. The truck that my lord has just now released.
We'll take up the matter after going through the judgment and then maybe I think the trial court has the.
My lord, my lord. In the earlier,
To the judgment, I think the trial court has the power to. I have forgotten the.
my lord. In
observation.
the earlier occasion also lordship.
Uh,
In another case, my lord,
Yes.
where that materials are in the
Something,
truck,
that,
my lord.
that it is included, that even it is not seen that.
Oil,
trial
that
court-
oil tanker, that is oil tanker.
We bring the judgment. Mr. N. Anand is present for the petitioner, leaves the matter on 15 July.
My lord, my lord.
Item 24.
May I please, my lordship? So this is revision petition against the order dated 13 to 25, my lordship. Page number 22.
A report has been called.
My lord, we have not received any report today, my lord.
Jima, what? What?
Truck, my
Jima for
lord.
a truck.
We need the report.
My lord, report is required, my lord.
Report has called.
Lordship,
Reminder, list the matter after
Lordship,
vacation.
since
After vacation, 16 July, we'll need the report.
long time, my lordship,
We need.
the truck is
I know, if the vehicles are always kept for a long time, we'll need the report.
Item 26.
May it please your lordship. Lordship, the instant application, lordship would recall on the previous occasion, lordship was pleased to call for a status report. This is an FIR after 10 months of alleged death by negligence on the part of a doctor, my lord. And lordship had gone through on the previous occasion of the judgment of Jacob Matthews. So lordship had the anxiety as to whether the preliminary inquiry was conducted or not.
My lord, here today, we have not received the case there, my lord. And status report also not received, my lord. Lordship may fix it any other date, my lord.
So lordship, the matter, lordship would had kept the prayer for interim open. So where if lordship would like to stay the matter today, then the matter may be fixed after vacation.
No, I would not like to.
Then lordship may fix a date next week, my lord. They may bring it on record.
From Hosai, my lord.
Hojai?
Hosai.
Because everything is on record, my lord. It is after 10 months.
Fix it on next week.
My lord,
We can fix it on next week.
my lord.
As per their convenience, a date may be fixed. If I may pray, my lord, on 24th.
On 24th, it won't come from Hojai. It will come on the last day.
26th, my lord.
See, we cannot fix matters for admission on those dates.
So lordship, I
Only
may,
after
again, if your
vacation,
lordship
I
gives
think.
me just 2 to 5 minutes time, my lord, I'll run your lordship through again, my lord.
Last time I heard you at length and then
My
I
lord.
did
Yes,
feel
my lord.
like.
Yes, my lord.
After hearing lordship was.
After hearing, I.
So, my lord, every day, my lord, the doctor is made to sit in the police station for 3 to 5 hours, my lord. Is it not the abuse of process of law, my lord? Without a preliminary inquiry as to whether there was gross negligence or not. I leave it to lordship's wisdom, my lord. If a stay would cause any damage to the prosecution, my lord.
Unfortunate incidents may.
Yes, my lord,
take
it's
place
most
and then
unfortunate, my lord, that lady expired
unfortunately,
during
this
childbirth, my lord.
harassment, they have to go through all this harassment.
Yes, my lord.
That day.
My lord, statute
If
prescribes,
I
my
would
lord.
hesitate, if there is something, some ground to grant stay, I won't hesitate. I always grant stay at the first instance. But when I feel like I have to go through the record, then I usually.
Then, my lord, the status report on next week, my lord.
Next week is not for admission. This is for admission, isn't it? Or for orders.
Actually, matter ought to have been for motion only, my lord, because lordship had called for a status report, my lord. Lordship had not admitted the matter. CD and status report, my lord.
Okay. কিন্তু সেইটো হেৰিকে আছে ন এডমিশ্যনত দিছে কল কৰি দিওঁ দিয়া CD and status report as called for is not received. We should remind that is the matter on last of all di dia nahibo na 26 June.
Deeply obliged, my lord.
Yes, your lordship.
That-
That case, madam.
So I have fixed it for today.
Madam.
So this order is already, that day only it's a type, but I couldn't. So this case against the petitioner stands abated.
Abated, madam.
So it stands abated,
Madam.
but you will have to approach that.
Trial
court
court,
also
madam,
to
will
abate
trial
it.
court, yes, madam, to get an
This
abatement. order.
present civil division is abated.
Criminal division,
Ah,
yes.
Oh, criminal division is
It
abated.
is, madam. We'll go to the trial court
Yes.
and give a death to you.
So you couldn't.
Deep level. Want to move on, appeal to the. Also, let me see what happened.
Maybe the lordship. My lord, may kindly say FIR, page 12. Well, it is the allegation that I was a candidate, the petition number 1 was the candidate in the ensuing Panchayat election matter. And the allegation is that I offered ₹500 to Miss Shahida Khatun, who is the victim of this case matter. It is filed, the case is filed by another person, not by the victim. The brother of the victim filed the case. Now, my lord, in an election, I have offered her 500 rupees, and I am a 65 years old man. And the allegation only against me that I hit it on her head by a dao. Now, on that day, my lord, I was on election duty. And the rest 2 persons are my sons and nephew. All of us went to the election campaigning. Now, lordship, there is only allegation against accused number 1 that he hit on her head by dao of my sister. 1. It is clearly stated. Kindly see page 13. And regarding the rest 2, my lord, allegation is that they entered in the house. That is 329 of BNSF. Now that is bailable, my lord. So for 1182, that is non-bailable. But it depends on the medical certificate, my lord. It depends on the medical certificate whether the injury sustained by her was grievous or simple. So, my lord, my humble prayer is this. This is totally election case. Election rivalry is there. They support one person. I am one of the candidate. This is my normal duty that I will ask for votes when I am a candidate. So my humble submission is that regarding other 2 persons, the offences are bailable. Regarding this petitioner 1 who is 65 years old man, that is our clear case. There is allegation that I hit it on her head. Now injury is most essential. My humble prayer at this is that, my lordship may kindly grant us interim protection and let the city call for a medical report. Because in maximum cases, my lord, so serious the report comes that the injury is simple in nature.
Because of the injuries there, my
Sometimes they die also.
My lord?
Sometimes they die.
But that is not the case here, my lord. Here is very 500 rupees I offered, my lord. What type of allegation is this?
That's only, my lord, that's as because the injury is there, my lord. The perusal of city is needed, my lord. Otherwise, it is different. Maybe a short death, my lord. Right?
Even
Get
that
the
be
city
in respect of accused number 1, petition number 1, because he it is the allegation. So others too, there is no allegation. There against them allegation is 329, which is bailable. 2 and 3.
That accused number 1 is difficult to grant bail. Others I can grant interim bail, only the accused number one is difficult.
65 years old man.
Maybe short bail, my lord, we will try to.
There is no age. It is young age now. At this stage, it is young. 65, you are very young now. Middle age is now 70 years. Above 70. 65, you are a young lad. If you are not 65, then you are very young now. The longevity has increased now.
Actually, my lord,
Earlier people used
the
to die
allegation
for
is
50.
allegation is ridiculous because if I hate a woman, I will not get any votes. So the history is only political rivalry. And the election, this is a purely an election dispute, my lord. However, I leave it to your lordship, my lord.
We'll call for the CD short date.
And 2 and 3 may kindly be protected.
Okay. Okay, then 2 and 3 can be protected, I think. The person who has hit on her head is the 65-year-old man.
Their offense is Belu. 118 is Belu.
Our learned counsel, Mr. M.U. Mahmood, no? For the petitioners, 1, 2, 3, who have filed this application under section 482 of the BNWS 2023 with fear for plea arrest, bail as they apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. K. Butcher, learned additional PP Assam. The allegation against the petitioners is that the petitioner number 1 seeking board offered ₹50 to the informant's sister, and when the informant's sister refused, the petitioners led by the petitioner number 1 went into the victim's house, and the petitioner number 1 hit the victim on her head, causing grievous injuries on her head. Most of the other petitioners have also assaulted the victim. So it is submitted that on account of political rivalry, the petitioners have been implicated in a false case. The petitioner number 1 is 65 years old, and it is not plausible that an elderly person seeking vote will hit any voter. Full stop. I have considered the submissions at the bar. The Illinois Additional PP has raised objections stating that the victim has sustained grievous injuries on her head, and the petitioners are not entitled to interim bail. Full stop. It appears that interim bail may be granted to the petitioner number 2 and 3. Call for the city, list the matter on. In the interim and in the event of the arrest, the petitioners number 2 and 3 shall be enlarged on bail of ₹30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioners number 2 and 3 shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall not exercise threats to the victim. And the petitioner shall appear before the IO on every fortnight till completion of investigation. And the petitioner shall refrain from such activities with which they are alleged. On breach of any of the bail conditions, bail order shall stand automatically cancelled. The petitioner number 1's prayer for interim bail is not allowed.
My lord, CD along with medical report kindly.
Or call for a CD along with a medical report.
Hello. My lord, may I kindly see the FIR page 12.
Yes.
My lord, entire allegation is against one Mozaharul Islam, my lord. Everything was recovered from his possession. And on his allegation, my lord, I was pursued by police. Now, police went to my house, but got nothing. I have annexed the seizure list, my lord. Seizure list, lordship would kindly see. That is, my lord, page 26. Page 26.
Mm.
Lordship would say from home seized on being shown by Mozaharul Islam, son of so and so. That is a Pulsar bike. I have a Pulsar bike. It was shown by Mozaharul Islam. And there is long property dispute because of all are related persons. My father and Mozaharul's father are own brothers. And there is property dispute. Now, these contraband items, all these things have been recovered from Mozaharul Islam. And Mozaharul Islam pointed out that in making documents, Mohibullah helped me. Mohibullah helped me. I am Mohibullah. So, my lord, on the basis of the statement of co-accused, I have been sought by police, and Lordship would say FIR is for 2nd November 2023. Lordship has said, kindly see page 12 again. FIR is dated 2nd November 2023, and now we are living in 2025. So these 2 years, my lord, police never went to my house, excepting on being identified by Mozaharul that the illegal activities through which the documents were
Now, charge sheet has been submitted.
charge sheet, my lord, charge sheet. I have no idea regarding charge sheet filing. I have no idea. But thing is this, my lord, what is the allegation against me? Allegation against me, Mozaharul pointed out that in preparing the documents, Mohibullah helped me. And on that ground, police went to my house, found nothing excepting my Pulsar bike. And Pulsar bike is taken by police. So what is the offense against me? So my lord is aware about statements of the co-accused is not enough to implicate a person. And over and above in the FIR, my lord, the entire allegations are against Mozaharul Islam. And we are long property dispute. That is my clear case, my lord. Kindly see my
You are cousins.
my cousins.
Mozaharul Islam and you.
Yes, my lord. Kindly see my case, page 4, my lord. Page 4, para 5. May I read, my lord?
Mm.
That the petitioner may state that only reason as to why the main accused Mozaharul Islam has implicated the petitioner is because both of their families are neighbors and their families have had a long-standing land dispute for generations on account of right of inheritance, and he wants to take revenge on the petitioner and his family members. Moreover, the main accused Mozaharul Islam and 4 others, namely Asadul Islam, Umar Saddiq, Jahangir Ali and Wasim Akram, have already been granted bail by the Honorable High Court by order dated so and so. So Lordship has already granted bail. My lord, may kindly see page 20.
He was behind bars, no? He was in the jail and he has cooperated with the
Jail, only few days he was in jail. Kindly see page 20. Page 20.
Yes, he is not required to stay in the jail
But thing is this, his staying in jail is natural because everything was recovered from him. But nothing is recovered from me. So there is gulf of difference between the two. And he identified me. That he helped me. Helping one person, I have no idea that how he will use this
He was in the jail
false
for 2
document.
months.
So helping one person.
Then he was released. Yes, what do you have?
My lord, here, my lord, my submission is that before your lordship, my lord, penalty will not come. My lord, an earlier matter, my lord, after perusal of the city, my lord, that was granted, my lord. So, my lord, because, my lord, during the course of investigation, the present accused petitioner is, my lord, implicated. So let, my lord, the CDB come, my lord. Then we have to find out, my lord, how, my lord, what sort of, my lord, that is the involvement is there. So short date may be given.
My lord, may I pray one thing, my lord? Yes, if my learned friend has said about CD, but actually I am totally innocent, my lord, since such more than 2 years old case. So nothing is there, I am there always. So my lord, some protection may be provided so that I may bring my vehicle, Pulsar vehicle. And that let the CD be called for. If any implications are there, then Lordship may reject my bail petition, my bail granting order. Because of old case, 2 years old case. Kindly see the Lordship is aware, delay defeat justice. So 2 years old, they could not find any implicating materials against me, accepting, seizing the vehicle. Well, how they will do? So my protection may be provided and CD may be called for, and thereafter already I am out of this because my vehicle is damaging. That is the problem.
Given short date, my lord.
From which place?
It is from Morigaon, my lord.
Nearby, my lord.
Short date, next date.
Next day.
Yes.
The next week, my lord.
Yes, next week.
Next week, on that day, interim may kindly be observed.
No, I won't observe. Call for the CD, list the matter on last of our date, huh?
On 25,
27 June,
My
last day.
I think Lordship may kindly observe that the interim may be. How lies story.
In my order, there are materials against him.
May I please, your lordship. My lord, offense for a statutory period of 60 days. My lord, I am 53 days in custody, lordship.
What is the offense?
Offense under section 69 of BNS, lordship. Having physical relation with false. The FIR, my lord, and your lordship perhaps will remember.
That day the CD was there, I have read
CD was
it.
there, your lordship had read
It
the.
was there, Lordship, there was Lordship, regarding that Lordship, some money, I have submitted Lordship that money laundering Lordship, that he questioned that it's not money laundering Lordship, that is Lordship.
Allegation was that there's a financial scam network going on, my lord, and 3 persons were caught by the police, and one of those persons, Ibrahim Ali, had implicated me. So on the last occasion, my learned friend had read out the CD where it was projected that I was the main person behind this. So your lordship had also observed that there were incriminating materials against me, my lord. Then we raised this issue that this is a case punishable with imprisonment up to 7 years. So in terms of Arnesh Kumar as well as Satinder Until, it is mandatory that they should have issued a notice under now 35(3) or earlier 41(a). And if it is not done, then the IO is also liable for departmental proceeding. That was our contention. So my learned friend has submitted that there's a checklist incorporating this notice angle, my lord. So now they have produced the checklist. So my lord, whether 35(3) notice was issued to me, if it was not issued, whether why it was not issued.
Name?
My name is Hidayatullah.
You want to see?
No, if lordship has seen, that will be enough. If they have been able to justify why notice was not issued against to me, my lord, then
This will be in the CD also, but this is not provided to them, no?
No.
This is not provided. Okay, then.
So Lordship, regarding Lordship, now the issue is Lordship whether without reading 41 in notice, he can be arrested or not also. When the punishment is below 7 years or below 7 years old. That is the court.
And today, the Lordship, this case is well, what Lordship, I have furnished that Ernest Kumar judgment. Where it is.
No, not with me. You can read it or it's okay. You can read it.
In Ernest Kumar's judgment, that this issue has been raised, Lordship. In Ernest Kumar's judgment, Lordship, the para 11, Lordship, where it is said, Lordship, that our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily and magistrates do not authorize detention casually and mechanically in order to ensure that we have observed above, we give the following directions. So there are some directions that Honorable Court has given. This point number 1, 11.1. All the state governments to instruct its police officers not to automatically arrest when a case under section 498A. This is regarding 498A. Thereafter also 11.2. All police officers be provided with a checklist containing specified subclause under section 41 1B2. Here, Lordship, what the Honorable Court has changed that a checklist has to be given. If we go by the section 41 1B2, the police officer is satisfied that such arrest is necessary when, as per section 41 B Lordship, that Lordship, if any even if there is the punishment is below 7 years or 7 years, he can be arrested. On what ground? Then Lordship, this 2 will come. 1, 2. The police officer is satisfied that such arrest is necessary to prevent such person from committing any further offense, for proper investigation of the offense, to prevent such person from causing the evidence of the offense, disappearance or tampering with such evidence and as may be, to prevent such person from making any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer, as unless such person is arrested, his presence in the court, but whenever required, cannot be ensued. Thereafter, Lordship, provided that a police officer shall in all cases where the arrest of a person is not required under the provisions of the subsection record the reason in writing for not making the arrest. So there is a, if police officer do not think
And
that
then
he,
they are released on,
but here in Ernest Kumar Lordship, it is some more clarification has been given that that is 11.5. If the decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of institution of the case with a copy to the magistrate, which may be extended by the superintendent of police of the district for the regions to be recorded in writing. So Lordship, here in as per the section, Lordship, it has to be mentioned in the CD, but here it is some more clarification has been given that it has to be communicated to the magistrate also within 2 weeks. So this is the changes. Some changes has been made, but it is not written in this observations that every person who has been called for under punishable under 7 years or below 7 years, he has to allow to leave, giving him a 41A notice. It is not that. Because Lordship, for 11.2 specifically says.
It's okay, yes.
What the mandate is, my lord, because your lordship has also dealt with this issue earlier also, my lord. What the mandate of Ernest Kumar is that actually Ernest Kumar did not bring anything new. It was already there in the statute. 41 1B2 CRPC lays down the parameters. That these are the grounds in which a person can be arrested if he is accused of committing offences punishable to imprisonment up to 7 years. Now another section was brought in was 41A notice. The 41A, whereby it was mandated that a notice may be issued to those persons who are accused of offences punishable up to imprisonment for 7 years. Now, since this was not being complied with, so the Honorable Supreme Court came up with this judgment. Primarily with 498A cases, subsequently the Honorable Supreme Court also brought in all offences which are punishable up to imprisonment for 7 years. Now, the mandate of Ernest Kumar, if Ernest Kumar is read as a whole, is that ordinarily First of all, the police officer
Yes,
has to decide.
ordinarily,
Or, yes, ma'am. First, the police officer
But
has to decide.
can be arrested.
No, my lord,
also.
there is a caveat to that. The
Oh.
caveat is that,
Yes.
first of all, the police officer has to decide why arrest is necessary. And if the officer decides that this is a case where I am not going to issue a 41A notice, this is a case which falls under the parameters of 41(1)(b)(2), then those parameters have to be communicated to the magistrate because the responsibility has been cast upon the IO as well as the magistrate to ensure that the arrest of the accused person was justified. Now, how that justification is to be ascertained, it is on the basis of those parameters. So those parameters have to be placed before the magistrate. I am not saying that the responsibility lies alone with the IO. Now, it has to be placed before the magistrate, and the magistrate has to see whether this case falls within those parameters. If it falls within those parameters, then the magistrate may authorize his remand. If it does not fall, in that case, the magistrate will have to release him. If it does not do, then what Anesh Kumar says is that both the IO and even the magistrate, the Honorable Supreme Court has come down heavily on them. Now, this was further discussed, my lord, in Until's case.
Yes.
Until's case, my lord, I'll just read one paragraph from Until. Yes. Until case, Honorable Supreme Court says that if there is because both have to be balanced, 41 and 41A. And if those things are not balanced, in that case, the person is to be released on bail. That is very specifically the submissions of my learned friends are reproduced in Until.
Yes.
Thereafter, Supreme Court says, I'll just read one paragraph, my lord.
Yes, please read.
Just one paragraph, my lord. We only reiterate that the directions aforesaid, these are Anesh Kumar directions, ought to be complied with in spirit, in letter and spirit by the investigating and prosecuting agency, while the view expressed by us on the non-compliance of 41 and the consequences that flow from it has to be kept in mind by the court, which is expected to be reflected in the order. It has to be reflected in the order that these things have been complied with. Despite the dictum of this court in Anesh Kumar, no concrete step has been taken to comply with the mandate of 41A. This court has clearly interpreted 41(1)(b)(1) and 1(b)(2) inter alia, holding that notwithstanding the existence of a reason to believe why police officer, the satisfaction for the need of the arrest shall also be present. Thus, subsection 1(b)(1) of 41 has to be read along with subclause 2, and therefore both elements of reasons to believe and satisfaction qua an arrest are mandated and are accordingly to be recorded by the police officer. So these has to be recorded. Why his arrest is necessary, the reasons for his arrest, and his satisfaction. What is his satisfaction? Why he's going to arrest this person? These have to be recorded.
There in the checklist, everything in detail.
No, when the IO produces this checklist to the magistrate will have to apply his mind on the checklist, on the forwarding report. Now, your lordship will see whether this has been done, whether in the forwarding report he has submitted anything to show why he has decided not to go for 41A or 35(3) and instead go straight to 35(2) and arrest him. That his reasons for this arrest and the satisfaction which he has derived, that why his arrest is necessary, why if I don't issue a notice.
Sufficient.
So this has to be also reflected in the responsibility of authorizing a detention does not only rest with the IO. IO's role is that he will arrest. He has a cognizable offense, he will arrest, he will produce it before the magistrate.
Plead the LCR, no? If we have to check that, then we will.
My lord, we have on my learned friend, I think that order is there in the case diary.
CD.
Case diary, my lord, remand order should be there, my lord, first remand order.
No, but in, or maybe.
Otherwise, I have a certified copy of the order also, my lord.
Okay, you have it.
Yes, my lord.
Okay, then it is not reflected in the order. That I can guess.
So anyway, I leave it to your lordship. Otherwise, he is 27 days in custody. One of the co-accused person who is named in the FIR, that order on the last occasion has submitted, he was granted interim protection by this honorable court. The FIR named accused person
But
has.
I have forgotten why he was resisting. I don't know. I'll come back and I'll hear him. There was strong resistance from him. So I have forgotten.
No, my lord, sure, my lord, your lordship will hear both of us, then decide, my lord. Or otherwise, if your lordship thinks he needs some more days, he needs to be in custody for some more days, that can also be done. Then after maybe a week or.
50.
A
Lala.
Lala.
LA. For the petitioner.
You're on behalf of?
On behalf of P. Kotoki.
On behalf of Learned Counsel, Mr. P. Kotoki has prayed for adjournment, list the matter on. Date na লাগিব. 29 July positively for hearing as this is a long pending matter. Highly okay.
May it please your lordship. Well, the item 33, I want to withdraw. I got the information the case is already charged.
Okay.
So petitioner will file it.
33.
33, my lord.
Learned Counsel Mr. N. Uddin has prayed for withdrawal of the petition as Sashid has been submitted
Yes, ma'am.
against the petitioner. Learned Counsel Learned Additional PP Mr. P.S. Locker is present. Petition is dismissed on withdrawal.
I am with this.
So, my lord, I've already submitted. The principle is that, my lord, that if those parameters of 41 1B2 and 1B1, that is what until says, because until further delineates the law on Arnesh Kumar and says that first thing that is required to be done by the IO is that he has to decide whether this is a case where the arrest is necessary. Then he has to record his satisfaction as to why this arrest has to be made. After he does these two things, then he will produce, because he has already arrested the person, he will produce the person before the magistrate. He will produce a checklist, he will produce a forwarding report, and he will satisfy the magistrate because the magistrate will authorize the remand. The 167 or 187 magistrate will authorize the remand and he will give reasons as to why the remand is to be done. Now, he has to satisfy the magistrate as to whether this was a case where a notice was not given or notice was not required to be given. No, my lord, I have not read the checklist, my lord. Whether the checklist will be in the checklist, they have to show, my lord. One thing is that they may have the reasons, my lord, they may have the reasons. That is their satisfaction. They may have the reasons. Now,
Very well.
but whether those reasons say why they have not given me the notice, because the requirement is that cognizable offense and non-bailable offense, they can always arrest. That itself is a ground that they can arrest. It's a cognizable and non-cognizable offense. The satisfaction which has to be recorded is why a notice is not required to be given. Not the requirement, because obviously, my lord, a person who is accused
From
of
1 to 18 reasons.
Hello. So reasons, my lord, whether those reasons are for arresting me or those reasons are as to why he has not given me a notice, why he felt the need to bypass the necessity of issuing a notice.
Checklist for arrest without warrant as per section 35B 2B and SS 2023 to accompany arrested accused forwarding report in case diary in pursuance of judgment reported in criminal appeal number 1277 of 2014 Arnesh Kumar versus State of
Madam, that is their recording. Now, your lordship will examine whether this is sufficient to bypass the need for issuance of a 41A notice. Offences being punishable with imprisonment for 7 years, that is something which your lordship will examine, whether it was necessary.
You're
Whether
behind bars for how many days?
27 days, my lord. And your lordship will see the offences. Page 14 is the FIR, my lord. I will also come to the merit of the offences, my lord. Page 14. No, sorry, page 14 is the forwarding. Page 12, my lord.
What is your name?
My name is Hidayatullah, my lord.
Who is for Ibrahim Ali?
Ibrahim Ali, my lord, he is referring 31. My lord. Page 12, my lord.
Yes.
Sir, with due regards, I have the honor to inform you that on 22nd May 2025 at around 4:40 p.m., a piece of credible secret information was received at Biswanath Chariari police station regarding an illegal money transaction network operating in various parts of Assam with its center of attention in Biswanath. Acting promptly, a police team led by Sub-Inspector so-and-so, that is the informant himself, moved to the PO for necessary action. The operation commenced at around 5:15 p.m. utilizing official vehicle of Biswanath PS bearing registration number so-and-so. During operation, 3 persons were apprehended at the scene, which is in front of Asami Rice Hotel, for their suspected involvement in the financial network. Their names are Pritam Hati Borua, my lord, he is not before your lordship. Anupam Bhorali, he is not there. Ibrahim Ali, my lord, is item 31. Now, next para, one suspected Omar Sharma managed to flee the scene. His details are as follows: Omar Sharma, so-and-so, so-and-so. Now, this Omar Sharma, lordship will recollect, I have given that copy of the order. He's also named in the FIR, and it has been specifically alleged that he fled away. And yet, my lord, he has been protected from arrest, my lord. Omar Sharma, my lord. Now, Maruti Desire vehicle number so-and-so suspected have been used by the accused was brought to the police station. Next part, my lord, here my rule comes in. During preliminary interrogation, it was revealed that the accused persons were operating multiple fraudulent current bank accounts of various banks, including Northeast Small Finance Bank, as mule accounts to facilitate the illegal transaction. Mule accounts, my lord, they use the accounts, they allow the deposit of the money, and then they keep some commission, and then they allow the money.
Carrier of loan.
Carrier, my lord, as mule accounts. They often use suspected groups for they often use suspected groups of the messaging application Telegram for the same. Accused Ibrahim Ali disclosed that he was acting under instructions from the following person, Hidayatullah. So Ibrahim Ali says that he was acting on my instructions. So I am perhaps his superior in the whole operation. Now this case has been registered under sections 61(2), 3184. 3184 is the equivalent of 420, my lord. Next is 316 subsection 2, that is criminal breach of trust. Next is 3182, that is 417. Cheating simpliciter. Cheating simpliciter is bailable. Now 3184 and 3162, criminal breach of trust and cheating and lordship knows they cannot coexist together. It has to be either cheating or it has to be either breach of trust. Now on the allegations which are there in the FIR, I don't understand which section has been attracted in this case, my lord. For criminal breach of trust, somebody has to entrust the money to these persons. Cheating, somebody has to be dishonestly induced to deliver some money to these persons, my lord. They ought to have registered the case under some other section, my lord. This is not a case which is covered by either cheating or criminal breach of trust, my lord. That is another issue with the FIR, my lord. So this entire thing, they have investigated the case. They will keep on investigating. Whoever are the culprits, my lord, they will face the consequences in trial if they are found guilty, either of these sections or any other sections which may be attracted, they will be punished. Now I am in jail for 27 days. I am saying that I was not even issued a notice. I was not given that opportunity of voluntarily appearing and cooperating with the investigation. One person who fled away, I did not flee away. One person who fled away, he has been given protection, my lord. So considering all these aspects, my lord, I am submitting that at this stage, my lord, his bail may be granted. He will keep on cooperating, my lord. Any stringent conditions the lordship will impose, he will fulfill, my lord.
He's only the other person who's granted bail was because his vehicle was being taken.
No, my lord. He is as per the FIR, I do not know what is there in the case diary. FIR says that if the vehicle part comes in later, FIR says that one suspected associate, Amar Sharma. So he's been specifically accused to be an associate, and yet he has been granted protection. So he flees away, my lord. Whatever his role was, he ought to have cooperated. Now I am not here to submit against him. I'm just trying to submit that a person who flees away gets protection from arrest. I have been arrested and I'm in jail for 27 days. 60-day offense is there, my lord. So let me cooperate, my lord. I will cooperate with the remainder of the investigation.
First, complete lordship, whether Ernest Kumar's husband is fulfilled or not. That I have furnished that checklist that is fulfilled, lordship. Because lordship, Ernest Kumar's husband has given some guidelines, 1 to 11.1 to 11.7. In the last part of the 11.7, it is the conclusive part. The failure to comply with the directions aforesaid shall, apart from the rendering the police officer concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before the High Court having territorial jurisdiction. So, but all these are not the connected. All are individual. 11.1 to 11.6, all directions are individual. That for non-compliance of this section, 41(1)(b)(2). For non-compliance of this section, you have to comply like this way, that you have to give a checklist. For even in 41A notice also, lordship, this is one more lordship. Notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the superintendent of police. So here also some strict rule has been made that lordship, that notice has to be given within 2 weeks. What is not the what did not said in the section lordship. So it has to be given in 2 weeks. If not, he can that can be extended by the SP only. So some rule, some strict guidelines has been given, but all are as it is. It is not like this. So you have to as you are your sections are 7 or 7 years, below 7 years. So you have to give in 41 notice. That is not there. So section checklist is there. Checklist contains everything, whatever the guidelines is there. So
he wanted to
one more
be certain whether the checklist is
second.
He is also agreeing with it.
Secondly, lordship, whether the court below has rightly pass that order or not order.
Yes.
Because
That is question.
I have taken my lordship, finally payment also lordship. That lordship in the second page, that section for 35A, there is a date, 38A.
Yes.
You can have 35C lordship.
Yes.
This is the order lordship, and that second page lordship, it is in the second page lordship, it is clearly mentioned what is their lordship. Why this the court has accepted that he should be given remand go for remand lordship. So this is mentioned lordship, and the trial court it is not the judgment lordship. This is the order only, and trial court has rightly and very well elaborately it is explained lordship why it is accepted lordship. So lordship, that part Anesh Kumar judgment is completed. Regarding lordship, that his involvement lordship, that regarding second part lordship, that lordship one co-accused has been released on bail. Whether his involvement is the same as this petitioner is not, no lordship. From the perusal of the CD lordship, it seems lordship that his vehicle was there lordship, and his name has not been implicated by all the accused persons. His name has not been implicated. That this person was there, this person was there, that is not there lordship. So lordship, his position is something below than this person's lordship. So these are this Hidayatullah is the main person, and what they have done lordship, even they did not talk in WhatsApp and mobile phone lordship. They used to there is a statement lordship will find lordship. They use some QR code, even for everything lordship discussion. They use some QR code only the scanning of the QR code. Everything discloses what they are going to say, what they are even. So it is a very big organized crime lordship. So lordship, at this stage lordship, and lordship, so many persons are yet to be arrested lordship. Lordship may kindly come to see peruse that the last part of the ion of lordship. That I have taken my key lordship. So many persons are yet to be arrested. Their custodial detention is required lordship. So they may temper anything lordship, because they are a huge crime and it cannot be completed within 20, 30, 40 days lordship. So lordship, we have the time when there is some economic offense, when some offense like this type of lordship. So this person only length of detention may not be counted lordship, because lordship we are interrogating him.
See, there's one catch,
Lordship,
one glitch. The sections added,
lordship.
these are not the proper sections added.
And lordship, they have, so lordship at this stage lordship, because this is not a criminal petition. This is a bail lordship. For considering the bail petition, whether 40 the earlier section lordship, I'm saying 406, 420 will come at the same time. These are not the matter of discussing in bail application lordship. These for on that ground lordship, bail cannot be given lordship. On that ground lordship, bail may not be given lordship, because these are the persons, because we are not filing the charge sheet yet lordship. If we are filing charge sheet, then on the same, then they may come on for criminal petition lordship. Even though there is at the time of framing of charge, that can be altered lordship. So lordship, at this stage lordship, when there is a huge crime, huge organized crime is more or something to some extent it is established in the CD lordship, and their custodial detention is required lordship. So lordship, at this stage it may not be granted lordship. Every page lordship, this is not lordship. Every page it is their complicity is there lordship. Their implications are there lordship. Witnesses, the bank witnesses has implicated him. They used to do some operate some. They used to hire some current account. They used to hire account lordship. After that, after transaction, some transaction, they used to close it. Again, they used to open another account. When a bank official asked them why you are some lakhs rupees, several lakhs rupees flowing in through their account within 1 hour, 2 hours lordship. So this is not a simple crime lordship, and there are custodial detention along with there are some documents are yet to be recovered, some seized lordship. So investigation is very nuisance lordship. So at this stage they are released on bail lordship now.
Contrary to what my learned friend has said, it is the only requirement which your lordship will see as to whether these offences are there against me. It cannot be that I am arrested for a particular offence, and when it is found that this offence is not attributable to me, then it can be argued that tomorrow some other offences may be attributed to him. When a person is, My lord, if we go straight to the origins of 41, 42, 43, 46, well, how is a person arrested and why is a person arrested? A person is arrested on the accusation of having committed a cognizable and non-bailable offense. First requirement is that I have to commit a cognizable and non-bailable offenses. Now the offenses they have registered this FIR under the non-bailable sections, those offenses are clearly not attracted. They have arrested me for these offenses. They cannot keep me in
What
detention.
the evidence against you?
No, my lord, I'm submitting on that. My lord, come to that point. They have arrested me for these offenses. They have not arrested me and they cannot keep me detained on a future for a future contingent event where they may add some other offenses. These are the, as of now, they have not added, this FIR has been registered for a considerable time now. They have not added those sections now, till now. As of now, these are the sections which remain. So when your lordship will decide whether my bail is to be allowed or I am to remain in detention, your lordship will see whether these offenses are attracted against me or not. That is one aspect. Second aspect, my lord, regarding that magistrate's order, that whether this is not a criminal petition, my lord, that is what was clarified in until. If the arrest is not in conformity with 41 and 41A, then the courts immediately have to release the person.
I'll just read out 3 lines. Foreign websites, many gaming sites are hosted outside India, escaping local rules and taxes. Payment tricks, this is your modus. Then checklist I'll keep with the CD.
Your lordship will also examine that part, that checklist part. While giving the checklist, they also have to satisfy the court why this notice was not issued and what was the necessity of arresting. Because that part has to be, that part, madam, not the necessity of the arrest per se, but the fact that why notice was not issued and directly arrest was there. That part also has to be there in the checklist in terms of both Arnesh Kumar and Satyendra Rangan.
Expecting it's not there, it is there, very much there.
No. That's your lordship will examine. If it's there, it's there, madam. If it's not there, we'll be getting the benefit, madam.
It's already there. All the points are noted down serially. I think you have, as a magistrate, you have seen the checklist.
I've seen the checklist. The checklist, what is done then? What normally is done is that these grounds are given. That on these grounds, this person is required to be arrested.
Yes.
Now, what once until does is that until goes a step further. Until says that in addition to giving these parameters, the IO also has to satisfy the magistrate. There are 2 things. One is the subjective satisfaction of the IO. One is the subjective satisfaction of the magistrate. That this is a case where notice was not required to be given because of this reason. Not that this person is arrested because of this reason.
Magistrate.
Yes, madam, I have the copy of the order. What the magistrate has done, madam, magistrate has not discussed anything.
Then he has to send in the magistrate order also.
No, not required, not at all,
Send-
not at all.
Now it is that point has come to that extent also that magistrate has not passed the order properly also, then that may be selected.
No,
Then
that is
I
not the
will
law.
confirm that
The
point.
lordship knows the law.
Because
That is not the
lordship-
law.
Because lordship in a, whether how magistrate has to write that order in a production order lordship, then how it has to be written, how it has to
How
be
the magistrate is supposed to pass the order?
There is some.
My lord, in terms of Arnesh Kumar as well as until, what the magistrate have, what the first the IO has to record, again I am submitting the same thing because perhaps my learned friend is not aware of this position that this order does not require to be challenged in a petition or revision. This can very well be examined and bail until is categorically clear on that.
Magistrate is supposed to.
First
pass
of all,
the-
my lord, what the IO will do is if it's an offense punishable with imprisonment up to 7 years,
Yes, yes.
the magistrate IO will decide whether this is a case because until says he
Yes.
will ask himself
Will
whether
not
arrest is
the
necessary.
IO decide.
So what? No, madam, that is the parameters are there in 41B.
Parameters are there. Is
So
recorded.
if he decides that this is a case where I am not going to issue a notice, he will have to record his reasons. He will have to record his reasons that this is a case
Where will the IO record his reasons?
in the case diary, my lord, and that is what will be given in the checklist as well as in the forwarding report. And this is for the magistrate to examine at the time of authorizing the remand, because remand cannot be a mechanical process, my lord.
Every paragraph that when the person was remanded,
My lord.
he has mentioned everything.
So my lord will see the order. I'll just read out the order. What has to be the, what is that?
Order. I have seen the order.
So what has the magistrate written, my lord? The magistrate has written, considering the materials available on record, nature and gravity of offense and
And everything is noted. Noted.
my
Hey, Amur, judgment, I will require a old file, Those same judgments. Judgment of file to old.
Because the entire issue is because of the judgment also. Entire issue is because of the judgment also.
কিন্তু জানবে
Judgment মানে গোটেই issue আৰম্ভ
কিন্তু জানবে
And Kumar is like that.
No, Vihan, Malad, that is not the issue, Malad. Constitution.
No, these are all, these cases are all relating to Vihan Kumar judgment.
Yes, my lord. The first of all, my lord, we
I
have
think
seen.
these cases are all relating to Vihan Kumar judgment, no? Or
Yes.
Not.
My case is Lordship after Lordship Pankaj.
My
Yes,
case is also after Pankaj Bansal, ma'am.
I have not.
And my lord, our case is.
So I clubbed all the cases together and I am hearing
Yes, my
him
lord.
today.
And the ground which I have taken, my lord, it is on the BNSS 47 and 48, my lord.
Yes, it.
My lord. Not 50 and 50A, my lord.
No, no.
My lord, let my friend argue, my lord. My first submission, my lord, in this case, my lord, additional submission, my lord. My lord, Article 21 of the Constitution.
Which BA number?
Motu kya, ma'am?
Please give me the BA number.
Huh? 27. I think there's a number.
BA number. No, not item number. BA number.
Was this one?
Because there are so many item numbers.
Yeah, I'm sorry, Malad, the list is not.
On top of the file.
Malad, my item is 27, that is BA number 1585.
And 20. What is the additional submission?
Malad, additional submission, Malad. Article 21 of the Constitution of India, my lord. That is there, my lord. It says, my lord, no person shall be deprived of his personal or
Yes, yes.
liberty except, my lord, according to the procedure established by law.
Yes.
My lord, we are not on the American law, which says, my lord, due process of law. So here the procedure has been written, my lord, section 47 and 48. Now, my lord, what everyone is saying, my lord, section 50 of the CRPC and section 47 is same.
Yes.
Ditto. Now section 50A and 48 of the BNSS is same.
Yes.
But one line is added, madam. Lord, may kindly see that, madam. So, my lord, section
One line is one extra.
one extra line is added, my lord. Section 48 of the, my lord, BNSS, my lord. Lord, may kindly have a look, my lord. Forty-eight one, my lord. But otherwise, same, my lord. Last line, my lord. My lord, it says, my lord, disclosed or nominated by the arrested person for the purpose of giving such information. It was earlier, it was there. Now, my lord, it is stated, my lord, also to the designated police officer in the district. Also to the designated police officer of the district. So this line has been added, my lord. So now, therefore, my lord, Constitution Article 21 says, my lord, the procedure established by law. Now, my lord, can my friend say, my lord, whether they had any designated police officer in the state, my lord, of any district, my lord? Asset.
So in case no designated police officer.
Yes, my lord.
No police officer has been designated, then or any person who will commit heinous crimes, then what will happen to?
Then what will happen, my lord?
What will be the result?
My lord, the reason for, my lord, this appointing this.
Will this Article 21 come in the way?
Yes, no, my lord. No, my lord, why this designated police officer should be appointed, my lord? Because, my lord, if I go, for example, my lord, if I go to Kokrajhar, my lord, and if I got arrested out there in Kokrajhar, my lord, they will give information over phone to my family that so and so have got arrested. So my family, my wife or anyone else will go to Kokrajhar, my lord. They are supposed to meet the designated officer. So why so and so has been arrested and what are the grounds, my lord? So section 37 of this BNSS, my lord, it states, my lord, the appointment of a designated officer. And to my knowledge, my lord, the state of Assam has not yet appointed this designated officer. Let them clarify whether he has been appointed or not.
And if not appointed, then?
Then
And if
everything,
a person
they have to
commits
appoint, my
heinous
lord. After
offense,
coming of the BNSS,
there's,
they have to appoint, my lord. They have to appoint, my lord. Section 37, my lord, how a designated officer should be appointed, my lord. That has to be seen, my lord. Otherwise, my lord, those Vihan Kumar and those judgment, my lord, are there, my lord. And I got arrested, my lord, after Bansal's case, my lord. That much, my lord. And my lord, moreover, my lord, In my case, my lord, the co-accused has been granted bail by your lordship. And that judgment,
Yeah, everybody's case I have granted.
yes, my lord, that order has,
Everybody's
yes,
case.
my lord.
Lordship, I am for the item number 28, Lordship.
Yes.
And out of same forwarding report, Lordship, your Lordship already grant bail, Lordship, and the ground
Yeah, then
arrest.
everybody's,
Lordship.
in everybody's case, I have granted bail.
Lordship.
Because at that time we were not informed about that before Pankaj Bansal.
Lordship.
After
After Pankaj, my accused is.
we are
after
not
Pankaj.
apprised about actually, not informed but apprised about before or after Pankaj Bansal.
More than
Some courts have rejected. I have heard
Lord.
bail.
more than 1 year, Lordship, in the study, Lordship.
Okay.
You may consider, Lordship.
Okay. Yes. Yes.
Lordship,
Earlier what you have submitted, if you submit now, then I'll just remind you that I already have it and you have submitted. Then it will cut short the submission there.
I'll short my subject.
Yes. No, then it will cut short. But if you haven't submitted earlier, then I will not interfere.
So, Lordship, the Article 22(1)
Mm.
on the country.
Mm.
So it says, Lordship, as soon as may be of the ground for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So he has to be informed regarding to his arrest law, ground of arrest law. So Article 22(1) says only to that extent, Lordship, to that aspect, Lordship, that he has to be informed. So Lordship, Lordship, one judgment, Lordship, thereafter found in 1950, Lordship. That is, Lordship, A.K. Gopalan versus State of Maharashtra. So Lordship, in 1950, A.K. Gopalan versus State of Maharashtra. This is the 6 judges bench, Lordship. 6 judges bench of Apex Court, Lordship. And Lordship, here in this case, Lordship will find this is regarding, Lordship, a preventive detention case, Lordship. And here also, Lordship, that issue has been discussed.
Yes.
That Lordship, Article 22(1). And here I would like to read a small paragraph that I have not furnished, Lordship, because it's wrong.
I do not have the
I will furnish this one also. Clause 1 and 2 of Article 22 lay down the procedures that has to be followed when a man is arrested. That ensures 4 things. 1. Right to be informed regarding ground of arrest. Second, right to consult and to be defended by a legal practitioner of his choice. Third, right to be produced before a magistrate within 24 hours. And fourth, freedom from detention beyond the said period except by the order of the magistrate. So here also the first point is also right to be informed regarding ground of arrest. In 1950, the six judges bench has not opined that it has to be in written form. Thereafter, Lordship, I have earlier submitted, Lordship, that Shobharam case, Lordship, 1966 A and 1966 1910 case, Lordship. Wherein Lordship has, I have earlier repeatedly read up, Lordship, so today I am not going to read up it again, Lordship. That Lordship, here it is mentioned that Lordship, Article 22 in para 20, Article 22(1) is in 2 parts and it gives to persons arrested a twofold protection. The first is that an arrested person shall not be detained in custody without being told the ground of such an arrest.
This is A.K. Gopalan's case. Another
No, sir, this is Shobharam case. Second 5 judges bench, Lordship. I have already submitted.
No, I don't have, I think.
This I have submitted earlier, Lordship.
Yes, you have submitted, but
1966
I don't have the judgment in this file. Maybe it may be in the record, but not in this file.
That I have submitted this one, Lordship. This is
A.K. Gopalan also I don't have, and then
A.K. Gopalan, yeah, I am submitting for it.
এইটো ঘৰত আছে ইয়াতে দিগদাৰ হ'ব লাগিব।
A.K. Gopalan. And thereafter, Lordship, A.K. Gopalan is 6 judges bench, Lordship.
And A.K. Gopalan
And Lordship, this is a State of Madhya Pradesh versus Shobharam and others. This is 5 judges. State of Madhya Pradesh versus Shobharam and others.
Okay.
This is 1966 SC 1910. So also here in this case also Lordship, para 20, I have already read out Lordship. That Lordship, the first is that the arrested person shall not be detained in custody without being told the ground of such arrest. And the other is that he shall be entitled to consult there and to be defended by a legal practitioner. So Lordship, in para 22, in Shubharam cases, in para 22, Lordship, some more clarification is there, Lordship. I consider that
Same Gopalan case, no? That same old Gopalan case
this
on the constitutional law.
every so many
That
all
famous case.
all family rights has been discussed here. 22 Lordship, I consider in Shubharam case, Lordship, second, I consider that there is a room for further deliberation on the point. I do not see how we can differentiate between arrest and different kind, arrest of different kinds. Arrest is arrest, whatever the region. Insofar as the first part of Article 22(1) is concerned, it enacts a very simple safeguard for persons arrested. It merely says that an arrested person must be told the ground of his arrest. Here it is, must be told the ground of his arrest. Thereafter, I will skip 2 lines. Thereafter, where the arrest is by warrant, the warrant itself must tell him. Where it is by an order, the order must tell him. And where there is no warrant or order, the person making the arrest must give that information. However, the arrest is made, this must be done, and that is all that the first part of Article 22(1) lays down. I find nothing in Article 22(1) to limit this requirement to arrest of any particular kind. A warrant of court and an order of any authority must show on their face reason for arrest, which there is no such warrant or order. The person making the arrest must inform the person the reason of his arrest. So everywhere, Lordship, is true. Lordship. There are some other paragraphs, Lordship. Lordship, I have submitted, Lordship. That is all regarding the Lordship. He has to be told, Lordship.
Here in this Eke Gopalan's case, paragraph 350.
350. Because Lordship, this is a big judgment, Lordship, and all the say articles have been
This is
discussed.
about the constitutional. This about the constitution also was discussed.
So this is a landmark judgment, Lordship.
Landmark,
And these two
very famous. We studied in law college.
Only one thing, your lordship will see that this is the judgment of full court, or lordship the opinion of descending judgment, lordship.
all are correct.
Because what I find in my copy, lordship, from 109, it is the opinion of Justice M. Patanjali Shastri. And again from page 175, it is the opinion of Justice B.K. Mukherjee. So that way, whether it is the full bench judgment or it is the descending judgment, that your lordship will consider. And second thing, lordship, in that case, it was lordship challenge that section 4.
Let me start. Yes,
Yes.
Yes.
So Lordship, thereafter Lordship, only in Pankaj Bansal came, it came Lordship, that after Pankaj Bansal has said Lordship, there has to be a written count of arrest. And thereafter Lordship, Prabir case again, R.K. Arora Prabir case came, Ihan Kumar came Lordship. Again Lordship, Akash Reddy came Lordship. Wherein it has been again stated Lordship that they simply told, he has to be told by saying that Lordship, the judge.
This is the final judgment. This is the last judgment.
So Lordship, whereas my submission is that Lordship, wherein there are judgments of full benches or Lordship, more than larger benches, Lordship, when there are the benches, Lordship, whether the two judges bench order can override that order or not, that opinion or not. That is Lordship. Because Lordship, and when there is a opinion of the earlier court in 1966, 1950, and at present also, Lordship, it is not that in earlier, at present in custody in 25, that is order also. When it is stated, Lordship, that is not the requirement of giving furnishing ground of arrest. And even one more ahead, Lordship, when I will going to submit, Lordship, that Lordship, when persons are spot apprehended, when person knows himself that what he is doing, when some recovery is being from his own residence, some narcotic substance has been recovered from his own residence. So for those offences they have been caught red-handed. Then also whether it has been some more elaboration is required or not, Lordship, that why you have been arrested, and that too, Lordship, we are not. It is not as if we are not giving them any ground of furnishing any ground of arrest. We are furnishing them some ground of arrest, but it has not been in conformity with the guidelines by the Probir Purkayastha and Bihan Kumar. Only because of that, Probir Purkayastha Bihan Kumar guidelines is not specifically done. That is long back from their judgment, Lordship. Whether it is for their releasing on that point, it is justified or not, Lordship, and go in first. Because, Lordship, earlier also I have submitted, Lordship, that Lordship, these are the procedure. The main thing is that he has to be informed, and whether he has been informed, that has been established that he has been informed, Lordship. Regarding his ground of arrest, that has also been informed, but it has not been in an elaborate manner. Yes, it has not been in elaborate manner. But when he himself knows what he has done, while he is carrying off 4 kgs of Yaba tablet, while he is carrying off 18 kgs of Yaba tablet, 25 kg or 30-40 kg of ganja, he do not know what he is doing. Why they are kept in some ways, why they have concealed it in some secret chamber, Lordship, if they do not know. In some cases, Lordship will find that they have kept it in a secret chamber of their vehicle. So all this comes to that they knew it. So they are informing them. It is not that we are not informing. IO and police investigation is not informing. They are informing them, but not the not to that extent that as the Bihan Kumar has stated. So Lordship, when one Pankaj Bansal has stated, even Pankaj Bansal has not stated regarding any specific guidelines. It is simply that he has written ground of arrest has to be furnished. In Probir Purkayastha, to some extent, ground of arrest, reason of arrest, differentiating, some areas has been made clear. Again, in Bihan Kumar, it is some more clarification. So, Lordship, I have already submitted earlier.
Yes,
also.
yes, because of that, how to interpret when there are two dissenting.
Because if you were following,
Dissimilar
if you are following that Pankaj Bansal, giving that ground of arrest, then Probir Purkayastha will say that it is not as Probir Purkayastha guideline. So it will go. Then we are following Probir Purkayastha. Then Bihan Kumar said this is the guideline. So Probir Purkayastha will again go. Now another husband will claim that this has to be done. Then Bihan Kumar will again go. So this cannot be the way. This cannot be the continue like this way. So because only the main purpose of the constitution, because everything depends on that main point is that, Lordship, Article 22(1) whether complied or not, and whether the mandate of Article 22(1) what does it says, it has to be informed. The simple, very simple say. That is in the that does not say that it is very simple. He has to be informed by difference by explaining in some other way. It will have always prospective, even though it may have some perspective, but it will not have any retrospective effect. So, Lordship, at least I will conclude my argument on to that extent, Lordship, that when there is 5 judges bench decision, opinion is there, 6 bench opinion is there, whether 2 judges bench opinion can override those.
Yes.
That much.
Sorry, my lord. 1 minute. You were saying that there's
Witnesses 4 examined. And my lord,
no,
14 months, my lord, in custody.
14 months, 20 days.
14 months, 20 days in custody, my lord. Arrested, my lord, on 31/3/2024. Dispute between family members, my lord. Due to land
31/3/2024.
lordship.
And how many out of 22?
Out of
witnesses?
22, my lord, 4 examined.
14 months, Lordship, search sheet given.
Search sheet given, search
frame,
frame,
4 witnesses examined, Lordship.
and search frame, my lord, in the month of September 2024. And
One accused, no?
one, my lord, only one.
Very dangerous offense.
Offense, my lord,
Huh?
due to land dispute, my lord, their own family members, madam.
Very frightening.
Today, my lord, my mother died,
Really?
my lord.
এইটো একেলগে দি দিয়ে জ্ঞান কুমাৰ গ্ৰাউণ্ডটো আছে ইয়াতে
I have annexed the notice also, my lord.
আৰু 5টা আছে একেলগে দি দিম 10টা আহিব
In the notice, nothing is mentioned. I have annexed the notice also. There is nothing, my lord, in that notice.
I think whenever about the Kolyan Shankar, Kolyan Shankar, long incarceration minute day down for.
Okay, okay. Yes, no, what are
Very NS of insanity.
Which paragraph?
Para 8.
এইটো নালাগে চিটটো নিদিব ওপৰতে লিখি দে No,
I'm finding. I will find.
oh, এয়ালো মানে যে গোটেইখিনিতে লাগিব Okay. So these matters are over, no? We have all clubbed together those matters. These are over, okay.
One thing I will point out is that just now I have been told and I have checked it that the judgment which is relied on by my learned friend, that is probably overruled by Maneka Gandhi's case. I will just check it and place before your lord.
Yes. That Gopalan's case.
Yes, Gopalan.
So overruled by
Yes.
Maneka. That I know.
Yes. That your lord.
But only the constitution part.
Yes. No,
Huh? Which one? No, not 22. I think Article 13 or 39,
yes.
as far as I remember.
That your
That-
lord.
that-
That your lord.
That we in school, I think college. Yes. Not cannot change the what of the constitution, basic facts, basic structure of the constitution.
That
Yes. Item 36.
May it please your lordship. Lordship, this is an anticipatory bail application, lordship, case diary was called for lordship. And last day, lordship, the dying declaration, lordship, has sought for lordship.
City we have received, my lord. The kindly peruse. Only my lord, all the parts, my lord.
Do you have the dying declaration?
My lord, there is no dying declaration.
But so there is a lordship direction from the court last occasion, lordship, they have, from their side, they have said there is a dying declaration.
My lord, so my lord may kindly peruse, my lord. Horizontal tag marks, my lord, not the vertical one, my lord. My lord, here the case is that, my lord, the petitioner number 1, my lord, accused petitioner number 1. And my lord, petitioner number 2, my lord. Here, my lord, the maternal uncle and aunt of the deceased victim. My lord. In the FIR, my lord, there is another accused, my lord. From the city, my lord, but I have come to know. Who is the son of these two, my lord, petitioner number 1 and 2. Now, my lord, before my lord perusing the city, may kindly peruse the para 3 of the petition, my lord. Page 4, my lord. My lord, may I read, my lord, that para?
Yes, please read.
That the petitioner begs to state, petitioner number 1 is the husband of petitioner number 2. On the other hand, the informant is own brother-in-law, that is the husband of the sister of the petitioner number 1. And thereafter, FIR name accused number 3 is the son of the petitioner and cousin of the victim. And the FIR name accused number 3 are in prohibited illicit relation which was noticed by the petitioner after they returning from Bihu program. That is the statement, my lord. Now, my lord, petitioner number 2, he is not before your lordship. Petitioner number 1 and petitioner number 2, my lord, before your lordship.
Petition number, accused number 3 is not before.
That's why I'm saying that the accused number 3 is not before your lordship. Now, my lord, here, my lord, that is the submission, that is the statement that there
Came to the house of the informant with weapons and committed theft of around
3 lakhs rupees of articles and thereafter set fire on the house of the informant. But that is not the fact. The actual fact is that there was no house available. And the informant burned some trees and leaves and tried to show it that there is a house. And we have stated it in paragraph number 9, page 8 of the petition.
FIR is at page 20, no?
Yes, your translated version is at page 20.
Yes, what do you have?
This kind of CD receipt, my lord.
Hmm.
Here, my lord, in this matter, my lord, that, before your lordship, my lord, there is a 12 numbers of petitioners are there. Amongst them, my lord, that is petitioner number 12, petitioner number 11, petitioner number 10, petitioner number 8, and petitioner number 3, and petitioner number 1. These are FIR and accused. Others are not. And from the my lord,
Petitioner number 8, 10, 11, 12, and 3.
yes, my lord, my lord, I think from
They are FIR named accused.
my lord, petitioner number 1 is FIR name. My lord. Then he is accused number 3, petitioner number 3, petitioner number 4 is also FIR name, my lord. Petitioner number 8, petitioner number 10, petitioner number 11, and petitioner number 12.
Yes.
Others are not. Here, my lord, after going through the CD, my lord, that's the records and from the statements of the witnesses also, my lord. They have found the implications of the, yes, my lord, till today, my lord, because the investigation is going on, my lord. We have found the implication of the petitioner number 1, my lord, Amir Hussain Bormia. Petitioner number 3, my lord, Saruk Ahmed Majar Mia. My lord, petitioner number 4, my lord, Kapul Hussain Bormia. My lord, here, my lord, in the FIR and my lord, that is in the, my lord, also in the, my lord, investigation, my lord, from the statement, my lord, name is stated as Kabuli instead of Kabul. This part are same, others names are also my lord. So, my lord, and in my lord, petitioner number, my lord, 8, my lord, Nazrul Islam Bormia. Petitioner number 10, my lord, Yasuddin Majar Mia. And to those who are not FIR name, my lord, petitioner number 11, Mehboob Alam Major Mia, and my lord.
He is FIR named Mehboob.
Oh, my lord, yes, my lord. They are also FIR name, my lord. And petitioner number 12, my lord, Iqbal Hussain Bormia. These names are my
Oh, these are only implicated, no?
implicated, others are not.
Not implicated. Okay, then.
Yes, my lord, the investigation.
These are all enlarged on bail, and those are FIR named accused are not enlarged on bail.
My lord, only my submission may be recorded that till date, my lord. Whether they are named, maybe in the further, my lord.
Yes, yes.
Yes. And my lord, one prayer is before your lordship, yes, because my lord, they may be my lord, directed to appear before the argument. You must stipulate it.
Those who are granted bail.
Those are granted.
Third learned counsel, Mr.
MR Sodial.
MR Sodial, learned counsel for the petitioners, ekor par 12 leke ase. The petitioners have filed this application under section 482 of the BNSS 2023 with prayer for pre-arrest bail, as they are apprehending arrest in connection with so-and-so PS case under so-and-so sections. Heard Mr. K. Bosho, learned additional PP Assam. The allegation against the petitioner is that the accused person broke the fences of the informant's land in order to encroach his land. Thereafter, the petitioners
Page 21 relevant part.
on 7/3/2025 at about 12:20. It will be afternoon, no?
Yes.
PM?
Well, midnight.
No, PM. It's PM,
PM.
afternoon.
12:20 PM.
No, my lord, it is Gatri Anuman.
Then it will be AM.
Acha.
12:20 AM.
AM.
Armed with deadly weapons, possibly entered into the the allegation against the petitioners, listen again. The allegation against the petitioners. no, allegation against the petitioners number 1, 3, 4. 1, 3, 4, 8, 10, 11, and 12. The allegation against the petitioners, or the petitioner against the allegations.
My lord, apart from my lord, FIR name accused, one non-FIR name accused person is my lord implicated. That is my lord, petitioner number 7, Farooq Ahmed Madar.
Farooq Ahmed.
His name is 7, petitioner number 7, my lord, who is not FIR.
The Farooq Ahmed is his FIR name.
Farooq Ahmed is not FIR. It's not FIR.
His name, named in the FIR.
Name in the FIR.
Yes.
Farooq is 7.
7.
1, 3, 4, 7, 8. Lihila. 1, 3, 4, 7, 8, 10, 11, and 12. And other accused named in the FIR. Etu likhila na, tarpiছত etu continue koribo, broke into the entered, broke into likhila niki? Land. And thereafter day on 7/3/2025 at about 12:20 AM, armed with deadly weapon, like dao, stick, etc., entered into his land, surrounded his house constructed with bamboo, cane, and tin sheets, and forcibly took the belongings of the tent house stored inside the house and set the house on fire. Full stop. The entire house constructed by the informant was engulfed in flames, and when he and his family members learned about the incident, they informed the police about the arson. Full stop. The house was reduced to ashes, causing damages worth rupees 3 lakhs. It is submitted on behalf of the petitioners that the informant has falsely alleged that his house was set ablaze, whereas on the contrary, there was no house standing on his land, there was no house constructed by the informant. Full stop. There was no house constructed by the informant. Full stop. The learned additional PP has raised serious objection against the bail petition, stating that the incriminating materials in the case diary against the petitioner number 1, 3, 4, 1, 3, 4, 7, 8, 10, 11, 12. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioners. At this juncture, I am not inclined to grant anticipatory bail. So this is I think can be granted. Yes, sir. To all of them. This cane and tent house. Yes. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioners number 1, 3, 4, 7, 8, 10, 11, and 12. Full stop. However, I have considered the submissions at the bar that the submission on behalf of the petitioner that they are willing to cooperate with the remaining part of the investigation. I have also considered the submission that the petitioners are willing to abide by any stringent bail conditions if imposed upon them. To stop considering all aspects, it appears that custodial interrogation may not be required. All the petitioners are enlarged on, all the petitioners number 1 of our biological likiriba, enlarged on are enlarged on pre-arrest bail. In the event of the arrest, the petitioner shall be enlarged on bail of rupees 30,000 each with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioners shall appear before the IO within 1 week and cooperate with the investigation. The petitioner shall appear before the IO on every fortnight till completion of investigation. The petitioner shall refrain from such activities with which they allege and maintain the peace. Number 4, the petitioner shall not exercise threats to the witnesses or try to influence them, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled, sent back the CD.
Deeply applies.
May I please, Your Lordship? My lord, in this case, on earlier occasion, Your Lordship was pleased to ask my lord for scan copy of the LCR, my lord.
We have it.
It is charge sheet case, my lord, page 9 is the FIR, my lord.
Yes.
My lord, there is no eyewitness, my lord. One man was found, my lord, dead.
Mm.
And on suspicion, my lord, FIR was lodged, my lord. And there is.
Before my learned colleague to complete my lord, I will not come to the my lord, that is on.
Okay, we'll give him some time. Short date, we'll give him some.
Lordship, kindly, if my lord, friend is not satisfied, my lord, upon my submission, my lord, he may take some.
Let him go to
There is,
the-
my lord,
no,
nothing, my lord, in this
We'll
case.
say we let him go to.
My lord,
the
here,
LCR.
in this case, my lord, in this case, my lord, only, my lord,
It has been submitted.
my lord, allegation is
No,
there, my lord.
please, let him go to the FIR. Learned additional Mr. K. Bosa has paid for time to go to the FIR. To the LCR FIR, no, to the.
My lord, tomorrow, kindly, my lord, please. Tomorrow, my lord.
No, this is evening. Tomorrow we have 61 cases. Please think about me also. I'm asking to think about me also at times and about them also.
My lord.
Till 8 o'clock, they are toiling, typing away.
My lord.
But it's not ending.
Monday, my lord. Diploma.
Yes,
Lordship, this matter was being heard yesterday,
I know.
and inquiries were required to be done to the satisfaction of my learned Peter.
Madam, here I have talked to OC concerned, my lord. No problem. It is in now. My submission is already heard, my lord. My submission is that one.
How can I remember? Even if I heard you. What about, oh, this is not a POSCO case.
No. There are many doubts in this case. There are
I'm
many doubts.
granting you pre-arrest bail for the petitioner. Jitu Moni Ojha, who has filed his application under section 482 of the BNWS 2023, with prayer for pre-arrest bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Hard Mr. It won't go river, only kidnapping, no? Nothing else?
Nothing else, nothing else.
Hard Mr. B. Objection.
My lord, kindly say out, my lord. My lord.
Please find a copy of the.
Altogether 12 accused were convicted in this case. Out of the 12, my lord, coordinated of the Honorable Court, suspend us into conviction and sentence, and also release 4 accused on bail. First one on, my lord.
Why he was not released?
My lord.
Why he was not released?
Because it was for initially 2 or 3 occasions, the objection did not file by the public prosecutor, then objection filed, my lord. That's why, my lord. The last occasion you're listed before this honorable court, that due to positive sign, and it also says that since the initially the case dealt with by my lord Justice Patuti Saika, so this matter may go there. But we have talked to we have also, my lord, visited history. No. That particular, my lord, notification will not apply in this case, my lord. It's only applicable in respect of bail. That's why, my lord, matter is again listed before this honorable court, my lord. Last occasion, my lord. You can see, my lord, on 6.
No, both sides have to be heard. The victim side also has to be heard. It is not that only the accused has to be heard. Victim side also, he has sustained, he or she has
Because
sustained
in the first appeal, my lord.
grievous injuries.
My lord, I will come to that. On the first appeal, my lord, bail granted where the informant has not been made arraigned as a party
Then
responsible.
why he was not granted bail? Why he was not granted bail?
No, granted bail, 3 accused. Granted bail. Wherein, my lord, informant has not made, arrayed as a party respondent. No objection made from the side of public prosecutor. It is mandatory, my lord. It is mandatory to array the informant as a party respondent in the criminal appeal as well. But without making party respondent, my lord, appeal file, then IA file, and bail was granted, 3 accused. Then after,
You see, victim, I do not know why nobody wants to hear the victim. Victim has to be heard.
no, yes,
He or she is the person who has
no,
suffered.
he is not victim, he is informant, PW3, Dr. Imran Hussain, my lord. Yes, not the victim, not the victim, my lord.
Informant related to the victim is a victim under section 2WA. Third learned counsel Mr. FKR Ahmed for the applicant. Learned counsel Miss T. Begum for the respondent number 2 and has full stop and full stop no, comma, and learned additional PP Mr. P. Botagur for the respondent state. Applicant to furnish copies of the application to the respondent number 2 who has submitted for time to file objection against the IA. List the matter on 17 July. No,
No, my lord, no, this no.
He is behind bars. You must think about him also.
Because during the course of trial, I was in jail. And immediately after passing impugn judgment order, taken into custody.
Yes, it's in the order. Please furnish copy during the course of the day. Within 2 days, Likidia.
May I please your lordship? Lordship, the petitioner herein is serving a sentence of 9 months, lordship. She is behind the bars. And lordship, there has been a delay of 113 days in filing the revision petition. So lordship, we had filed an IA for condoning the delay of 113 days. The reasons are genuine, your lordship. She was behind the bars, so hence there was a delay of 113 days. Lordship, I have taken the steps, lordship, in the month of February. Lordship, the notice was served, lordship. Perhaps my learned friend has.
She was
Lordship,
behind the bar. She was behind bars. I think delay can be condoned.
Lordship.
Her doctor, no?
Yes, lordship.
Your name?
Dr. PP Medhi, lordship.
PP Medi for the petitioner. Srimati Rita Das. Who has for the petitioner and applicant. Applicant Rita Das, who has filed an application under section section 2 idea, who has filed an application with prayer for condonation of delay of 115 days in filing the criminal division petition challenging the order dated 25/7/2024 passed in criminal appeal number 4 of 2024 passed by the learned session judge Borpeta upholding the conviction upholding the order of conviction and sentence dated 19/2/2024 passed in NI case number 58/2018 by the learned additional session Borpeta. It is submitted that the applicant has sufficient grounds for condonation of delay as she was behind bars. Full stop. The applicant is in the jail and she was unable to file the criminal revision petition within the period of limitation. No malafide can be attributed to the applicant. The learned heard Mr. J. Deka, learned counsel for the respondent. I have considered the submissions at the bar. It appears that delay may be condoned. Hence, application is allowed and delay of 115 days is condoned. Registry to register the connected revision petition.
And one IA is also there. Another IA for.
I will be registered.
There are 2 IAs, lordship. Second IA is for the bail, lordship.
No,
So
they will register
along with the revision petition. I'm deeply obliged, lordship.
Yes. Can I? Item number 48. Item 48. 62 होगा नहीं? 46 नहीं होगा. 48 side. Appellant is not represented today. This matter is a long pending, this is a long pending case. List this matter positively for hearing on date of the details, 31st July. To sub, on failure of appearance of any of the parties, this appeal will be decided on merits. Huh? Only appellant, huh? Learner additional PP, Mr. B. Sharma is present for the respondent state लिख दीजिए. For the state भी लिख लो, respondent state.
What is the file?
49 ना?
49 was appeal, my lord, criminal appeal.
You can
Can it be, my lord, immediately after, my lord,
You can
reopening?
start, we will continue. Or you do want to start?
I have misplaced the file, my lord. I brought to the court. Right now, I am not having the file.
Okay. No problem.
Hopefully, I'll do. Huh? Huh? I'll do.
Learned Counsel Mr. B. Chaudhary, no?
BM chosen.
BM Chaudhary has submitted that the file has been misplaced. This
Not misplaced, man. I brought to the court, my lord. Right now in the courtroom, it is not here, man.
Okay. Has paid for
File
adjournment.
is there, my lord. So
Okay.
immediately on reopening,
Has
my lord,
submitted for adjournment. List this matter on 31st July positively for hearing.
I'm
Like
obliged.
this is a long pending matter.
My lord.
I'm also blessed. I had a long day.
My lord, my lord.
Lord, regarding item 48, my lord.
Oh.
Lord,
Oh,
my-
sorry.
Lord, my presence will be recorded.
Yeah.
Matter would come up on 31st July. PJ Fukan.
Appellant is present. List this matter positive for hearing. लिखी दीजिए.
31st. Most obliged.
Yes, I 51 record होने order लिखी थी भाई आगे तो लिस्ट लगे appellant is not represented on the absence of any of the parties this matter will be decided on merits लिखी थी and आगे date of adjournment লৈছে 2025 item 53
My lord, the end of the day, my lord, yes, my lord,
I
Not done. Here, settlement today, he is not interested.
on the other day, lordship has observed that case is otherwise, my lord, lordship was supposed to consider the main case today because lordship has observed that the main case has, petitioner has some merits.
but in
That is
bail
why.
no I maybe not in bail okay then if you want to start you can start we will continue part by part
Yes, my lord, that can be done. Yes,
meanwhile he can go through the
yes, yes.
case record and he can who wants to go to the case record there are three of them you shuffle who wants to go to the case record who will take up the second part of the hearing it will come after vacation
I know, I was 7 years, 7 years. আর আইএ তো আইএ কিছু ফাইল করেছিল আইএ তো গোটে কেখানি দিয়া Yes.
you want the LCR then you can take it
LCR is good.
but you will have to be prepared for the after the vacation yes
Here, my lord, the informant is the mother of the victim, alleged victim, my lord. My victim is one, my lord, Senas Khatun. She is a married woman having, my lord, 2 years old daughter, child, my lord. So allegation is that, my lord, that she has been, my lord,